This is the Supreme Court. Is quoted below. The Honorable Supreme Court, by the said order dated April 8, 2025, had never put a restriction to look into the legality and propriety of the creation of such supernumerary posts. Therefore, the present challenge is no way affected by the said order. The state has sought to justify the creation of the said vacancies in the name of supernumerary posts on the ground the state is obliged to fulfill the constitutional mandate of Article 21, capital A, to provide free and compulsory education to all children of the age 6 to 14 years and to follow up legislation, the Right to Education Act 2009 puts the state under the obligation to provide adequate number of teachers to the schools. As such, it has taken a decision to create supernumerary posts to absorb the waitlisted candidates of first SLST 2016 to meet a special exigency. The same being a policy decision is not open to judicial review. The said justification is not tenable in as much as it is a settled position of law that policy decision is open to judicial review if it is found to be arbitrary, unconstitutional, and in violation of the statutory provision. Of course, cautious approach is needed when such policy is based on cabinet decision, as has been held by the Honorable Supreme Court in the case of Himachal Pradesh Niji Vishayak Parishan Kendra Sangha Supra, cited by Mr. Kalnan Bandyopadhyay, learned senior advocate for the respondent number 289 to 301. However, in the present case, even if the said test is applied, this court cannot foreclose its jurisdiction of judicial review under Article 226 of the Constitution, as the decision is arbitrary and in complete violation of the extant rules. In the backdrop of the decision cited by the learned Advocate General in the case of Bhikari Charan Kuntia, Pushpa Rani, official liquidator, and Lieutenant CDR M. Ramesh are of no help to the state. In this context, the observation of the Honorable Supreme Court in the case of Manohar Lal Sharma at paragraph 14 being relevant are quoted below. On matters affecting policy, this court does not interfere unless the policy is unconstitutional or contrary to the statutory provision or arbitrary or irrational or in abuse of power. The Honorable Supreme Court in the case of BP Singhal and SR Mumbai has held that though no reason to be assigned for the discontinuance of the pleasure resulting in removal of governor, but even then the power under Article 156(1) of the Constitution is open to judicial review if such power is exercised in an arbitrary, capricious, and unreasonable manner. No doubt the state has the obligation to achieve the constitutional mandate enshrined under Article 21A, but to get it, the state cannot compromise with the rules and regulation framed to regulate the appointments of the teachers. In the present case, such compromise has been made to give appointments to the waitlisted candidates of an expired panel. The argument of the learned Advocate General that a discretion can be exercised for creation of supernumerary posts to promote the object and purpose of 21A of the Constitution, Article 21A of the Constitution, without taking recourse to a fresh selection process cannot be accepted for the reason that such discretion has been exercised in an arbitrary manner in violation of the relevant rules. The vacancies so created in the name of supernumerary posts, since are new vacancies, those are required to be filled up in the new selection process. The petitioners being eligible had participated in the first SLST 2016 but could not qualify. However, with their such eligibility, they are subject to age bar, entitled to participate in the next selection process to offer themselves against those new vacancies. But the petitioners, in view of the decision of the state to exploit the said vacancies to accommodate the said waitlisted candidates of the earlier selection test, that is first SLST 2016, have lost the said opportunity. The said decision, therefore, certainly offends the constitutional schemes of Article 14 and 16. The Honorable Supreme Court in the case of Raj Kishore Nanda has held that it is settled legal position. The vacancies cannot be filled up over and above the number of vacancies advertised, as the recruitment of the candidates in excess of the notified vacancy is a denial and deprivation of the constitutional right under Article 14, read with Article 16(1) of the Constitution, of those persons who acquired eligibility for the post in question in accordance with the statutory rules subsequent to the date of notification of the vacancy. In this backdrop, the argument of the respondent that the petitioners being unsuccessful and waitlisted candidates being successful, the waitlisted candidates being successful in the first SLST 2016 are wholly different classes. As such, there is no infringement of Article 14 of the Constitution is misconceived. Therefore, the challenge to the locus standi of the petitioner to maintain the writ petition and to throw challenge to the impugned notices is overruled. The creation of vacancies in the name of supernumerary post have been sought to be justified from another angle, that is, state in exercise of its executive power vested in it under Article 162 of the Constitution can create such vacancies. The said justification is not tenable in as much as the executive powers so vested are subject to other provisions of the Constitution. In other words, executive powers cannot be exercised to defeat the right to equality guaranteed under Articles 14 and 16 of the Constitution. The decision of the Honorable Supreme Court in Rai Sahib Ram Jaya Kapoor and the decision of the Honorable Division Bench Sharad Kumar Singh have explained the scope of executive power under Article 162 of the Constitution. There is no dispute that executive power of the state shall extend to the matters with respect of which to which the legislature of the state has power to make laws, but exercise of such power is not immune from judicial review when it is done arbitrarily, capriciously, or unreasonably. The decision of the Honorable Supreme Court in the case of Samser Singh and Hurinath, cited by learned Advocate General, is on the issue regarding extent of power of governor in conducting the business of the government under Article 166(3) of the Constitution. But the issue is nowhere connected with the present issues under consideration. The Cabinet Memorandum dated May 5, 2022 has recorded grievances of the candidates in the recruitment process of first SLST 2016, which inter alia indicates that the proposal of creation of such vacancies was to instill confidence in general public in the matters pertaining to education and involving public environment. It is rightly submitted by Mr. Bhattacharya, a senior counsel for the petitioner, that constitutional morality must prevail and cannot be replaced by political morality. Paragraph 146 of the decision of the Honorable Supreme Court in the case of Srinath Balasaheb Patil being relevant to the contest is quoted below. Contention of the respondent that the political exigencies required such measures to be taken needs to be rejected. The constitutional silences cannot be used to introduce changes of such nature. The Honorable Supreme Court in Chandan Banerjee has noted the following definition of term supernumerary post from Oxford English Dictionary: present in excess of the normal or requisite number, or not belonging to a regular staff but engaged for extra work. A supernumerary post is defined a post exceeding the usual stated or prescribed number. There is no dispute with regard to the nature of supernumerary post. A supernumerary post is a temporary additional position created for a limited time to accommodate an employee when a regular post is not available. The Cabinet has approved the proposal as contained in a Cabinet memo dated May 5, 2022 to absorb waitlisted candidates of first SLST 2016 in the vacancies created in the name of supernumerary post. Therefore, conceptually, the supernumerary post is a post to be created to absorb an existing employee when such employee could not be accommodated in a regular post. There is no dispute with regard to the proposition of letdown in the case of Horen Borgian, cited by Mr. Kalyan Bandyopadhyay, that supernumerary post denotes creation of temporary post outside the cadre personal to the incumbent. However, the said decision is of no help to the respondents. Decision cited by the learned Advocate General in the case of Pushpa Rani to contain the supernumerary post created at the same time in different cadres can also be constitute part of the cadre is completely irrelevant to the present issue. The waitlisted candidates of first SLST 2016 were not in employment. In fact, the panel and waitlist of the said selection test had expired long before the cabinet approval of the proposal of creation of supernumerary post in the name of vacancies in the name of supernumerary post to accommodate the said waitlisted candidate. Interestingly, Finance Department, Government of West Bengal granted its no objection to the proposals to absorb, quote unquote, absorb the waitlisted candidates subject to the validation of panel. The cabinet was aware about the position that the supernumerary post cannot be created to appoint a person. As such, consciously used the word to absorb in the cabinet memorandum dated May 5, 2022. The Honorable Supreme Court in Devdatta Supra has held that the term absorbed in service jurisprudence with reference to the post implies that an employee who has not been holding a particular post in his own right by virtue of another recruitment or promotion to that post but is holding different post in a different department is brought to this post either on deputation or by transfer and is subsequently absorbed in the post with, whereafter he becomes a holder of that post in his own right and loses lien on the present post. Summing up the discussion made above, I am of the opinion that supernumerary post cannot be created to appoint the waitlisted candidates of first SLST 2016 for the subjects work education and physical education. In terms of the Rule 2013, the panel of first SLST 2016 was remained valid for 1 year from the date of publication of the panel of the waiting list or date of advertisement of the next recruitment, whichever is earlier. The recruitment notification dated December 16, 2016 also stipulates the same time limit for the life of the said panel. The panel has admittedly expired on December 11, 2019, long prior to the date of cabinet approval of the proposal of the School Education Department to create vacancies in the name of supernumerary post to accommodate the waitlisted candidates of the said expired panel. The Honorable Supreme Court in the case of B. Vallubhan has held the life of panel as is well known must be for a limited period. It is governed by the statutory rules. The following extracts of paragraph 9 of the decision of the Honorable Supreme Court in the Jagadish Chopra being relevant is quoted below. Then paragraph 9 quoted, the decision of the Honorable Supreme Court in the case of A.P. Agarwal cited by the learned Advocate General is completely misplaced in the facts and circumstances of the present case, inasmuch as in the said case the validity of the panel was not extended. Rather, the second candidate of the panel was appointed in terms of the office memorandum as the vacancy had occurred due to the resignation of the first candidate within 6 months of joining. The order of the court cited on behalf of the state is of no help to the respondent. Rather, it supports the case of the petitioners inasmuch as in the said case, this court had dismissed the writ petition, accepting the submission made on behalf of the commission. The panel has expired long back. In the case of Gujarat State Deputy Executive Engineer Association, Supra, the Honorable Supreme Court has explained that a waiting list is in the present case. There is no issue on the what the waiting list is. In the present case, there is no issue on the validity of the waiting list. Therefore, the said case has no manner of application. It is settled position of law. Waiting list cannot be treated a perpetual reservoir for filling up the future vacancies. The argument of the respondent that the life of the panel stood extended due to the pendency of the litigation in respect of first SLST 2016 is completely unacceptable, inasmuch as the selection process was conducted in terms of a statutory rule. The decision of the learned single judge of the Rajasthan High Court on behalf cited on behalf of the respondent number 289 to 301 in the case of Rambabu Kohli on this point is factually distinguishable. The Honorable Supreme Court in Sulekha Chandra has specifically held the appointment divorced these statutory rules is void ab initio. That being the position, I am unable to accept the argument of Mr. Sengupta that supernumerary posts have been created as a gap-filling measure since first SLST 2016 is governed by a statutory rule. Therefore, on this court, the judgment of the Honorable Supreme Court in the case of Kantri will be cited on top of the respondent number 7 to 207 is of no help to the said respondent. The decision of the learned single judge of this court in Saroj Kormagal is no pointer to the issue under consideration. Argument of Dr. Patro that the substantive post cannot be equated with the supernumerary post. As such, the rules of 2016 is not applicable in respect of the post created by impugned notification is completely fallacious inasmuch as the waiting list is in relation to first SLST 2016, a selection test governed by a statutory rule that is said rules of 2016. The Honorable Division Bench of this court in Rajiv Brahma has dealt with first SLST 2016 for recruitment of assistant teachers in upper primary except physical and work education in government schools. Therefore, the said decision has got no manner of application in the present case. Conclusion, in view of the discussion made above, the impugned notices being dated 19 May 2022 and 14th October 2022 are set aside and quashed. The connected application can 11 is dismissed. There shall be no order as to court. Let the writ petition listed in monthly combined list of January 2026 for considering disposal of other issues involved in the writ petition. Black pen, black pen. এই ঝোলাতেও পারে সত্যি দর্শনীয় এটাই জানে এটা দিয়ে দেবেন আর কারেকশন আছে কতগুলো ফার্মে ঢুকান পরে দেখবে যে এই লাইট বন্ধ করো জল খাবো
till date, passed and communicated to the petitioner immediately thereafter. Stop. If the prayer of the petitioner is allowed, comma, the necessary consequential step in the assistant professor of or now it is expected now as per the rules of recruitment, the preliminary model answer key by the right stuff. The as the answer of the said assistant professor was found to be incorrect by the expert, comma, then the court um, uh, then a doubt rises in the mind of the court with regard to the uh, competence of the uh, assistant professor whose um, whose assistant professor engaged by the commission to act as the paper checker. Stop. Next, the petitioners asserts that the answer of the assistant professor is also correct, relying upon certain study materials annexed to the writ petition. Stop. It is an admitted fact that the court is not an expert and the court cannot substitute its opinion in place of the experts. Stop. The only option that is left to the court is to refer the matter to the commission once again to revisit the issue as to whether the the answer provided by the assistant professor is proper or not. The commission shall take a decision now if the answer provided by the assistant professor is found to be correct, comma, then the answer provided by the petitioner shall be treated to be correct. Stop. Next, a decision shall be taken by the commission at the earliest. Stop. Next paragraph. As the petitioners submit that the process of credential verification is going on, accordingly, as an interim measure, the commission is directed to permit. How many marks short is petitioner number 1?
Position number one mark. One mark.
All right. Permit the petitioner number 1, petitioner number 2, 3. How many marks?
No, 3 not. Did it that work?
Petition number 3, my lord. It's 50, 65 and 69.
4 marks short.
4
Cannot be given. 4.
4, my lord. 3 marks then.
3. 5.
1.
1. Kali 5.
No, 5 has already been, my lord, called
Oh,
for.
5 has called for interview. All right. And 6 doesn't get it. All right. Kali 2 জন. 1 and 2 though. 1 and 2. 5 has got 3 marks short.
Yes, my lord. 5.
Acha, 5 ke diye dein. 5 in the verification verification process subject to the report, no, not report, opinion of the expert committee, not expert committee, opinion of the commission. ঠিক আছে? The writ petition stands disposed of.
My lord, that should be petition number 4, who is 3 marks short.
আচ্ছা, 4
5 has already been called.
qualified. 1, 2 and 4.
But this কি করে হতো? But just
সেটা
one
অমনি পাস করে যাবে।
but one request,
Yes, sir.
kindly, if you lordships grant us liberty to appoint any other expert committee apart from not
It
other.
is your committee, it is your expert, it is your body. The court
No,
has not restricted.
court expert is not my body type. Not kindly appreciate is we don't have any professor. We do not go give any bar to professor or anything. SSC
I
is
do
a
not know. It
no,
is
no.
your
This
choice.
is from the recognized university. We take it.
Yes, recognized university is giving wrong answer. Somebody is saying no, different opinions. What can be
Therefore,
done?
okay.
Neither you nor this court is an expert.
No, I am not expert.
So we
I
do
am.
not know what
I
is the
do-
correct answer.
I do not
My
know.
lord, the commission may take into consideration the books, my lord, that we
Yes,
have, and that
the commission will take into consideration the study materials relied upon by the petitioners annexed to the writ petition. Yes, 5.
my lord, 5, my lord, I am for the petitioner here, my lord. The subject is Sanskrit.
There are 15 petitioners here.
My lord, I have paid the court fees.
Now, Mr. Bandopadhyay is saying something.
My lord, 15 people, different cases cannot come together, my lord.
What is the matter?
My lord, 15 petitioners are challenging the same questions in respect of subject Sanskrit.
Same question, same.
Same question.
All Sanskrit. Which question?
Yes. ma'am. There are different questions, my lord. Mainly three questions are there, my lord.
They cannot be clubbed together.
Question.
Same now.
My lord, question number 6, question number 48, and question number 51.
All three have got all 15 same.
Same question.
No,
All
no.
15 are challenging the same question. They have different question booklet series, but
Question is the same.
question is the same.
And the preliminary answer was proper.
Preliminary answer, we have raised objection on the basis of the preliminary answer. And my lord, in the final answer key, it has not been changed.
Right.
We have annexed, my lord, recognized books of having ISBN number, that whatever we are saying is correct. What, my lord, we are praying, my lord, let the commission, other than who have considered any other expert, and come back with a report, my lord. Because, my lord, when there are, I have not annexed one, but several, my lord, recognized books showing that our contention is correct.
Only 15 petitioners.
Brother, out of 15, brother, only 1, 2, 3, 4, 5, 6, 7 7 persons have objected.
Have
And
objected, others have not.
no. Apart from that, Mr. Dasgupta, kindly allow us to speak at least. You people are not allowing anybody. This 7 of them. Now, 114. Kindly come to page 114.
Yes.
Someone raised 114 4 objections. 115 2 objections.
114, I see 3 objections, not 4. It is Mamata Maiti?
Yes.
3 objections.
3.
Three.
Yes, sorry, Miller. 3. It should be 3. And 115 2 objections.
1.
One objection.
Yes,
One.
1 objection. So,
116.
116
2.
2 objections.
117. 3.
117 3 objections.
How have you considered? Just let the court know.
Miller, this is all the just 1 minute, Miller. Huh? Miller, this is the Miller, this is total 975, no? Miller, in one question, 975 raised objection. In another question, 303 persons raised objections. Now, Miller, this has been dealt with. We have sent it to the expert. Now, expert has said the answers are question number 47. Answer are unchanged with original master key. This is expert's opinion. That whatever it was earlier there. 24 to 47. All questions are there. And wherever the change, milord, that they have not raised objection there. The objections which were raised by them, expert court says that these are unchanged with
Tell
original.
me one thing, you all recognize the books which the petitioners have annexed. And in
We
other
have-
matters also, I see they have annexed
we have
books.
not we have not recognized any books.
That means these books are recognized.
There are so many books in several places, several persons are there.
Why don't you all publish something that these are the books that the commission recognizes so that
No,
everybody gets to know?
commission is not the person to do it. If the education department will do it or the college will do it, we are only meant to conduct the examination, not any other things.
Right. Now they
SSC
are,
has nothing to do. SSC,
they,
Malad, kindly appreciate one thing. SSC, just I tell you, SSC doesn't have their own professor. They appoint professor, assistant professor, whatever they are doing from the recognized universities. Only to this extent. Thereafter, whatever comes from the different university, different professors, these are set, paper setting. Then they give a also preliminary answer key. That we publish. Even now, if anybody raises any objection, we don't deal with that. We send it to the expert committee. The expert committee will decide it. But I am not the person who will decide paper. I am not the person who will decide the correct answer. I will not decide, Milord, whether it's wrong or right. Rather, Milord, I am just, Milord, carrying on the work. I am a bridge between everyone.
now the petitioners or anybody who's coming here, they are annexing copies of the study material from recognized bodies.
Milord, there may be in one, Lordship knows, Milord, in one point, there may be several opinions.
That be so, then all answers have to be correct, treated as correct.
No. The person who is writing the book, what is his authority to write the book? That is also seen. If I today I have write a book for geography, and
No,
get
then
it,
that book has to be recognized,
no,
not
if
by
I get it,
anybody.
no, recognition is not a factor. If it is recognized, finish. Today I am writing a book on tort. I am a lawyer on tort. Now it is recognized.
No, it is not recognized, sir. You get your
No,
book
and
recognized.
appreciate this. If it is recognized, I am saying if it is recognized. If the
Yes.
judges come to a point, no, this is the point of law is not correct.
Then it has to go to an appeal forum.
Even if your lordships does not rely upon any books, Lord, where the certain explanations are there. Therefore, one has to go by the expert opinion. My lord, there for few persons there cannot be a truncated route. This route is followed for everyone.
The other book which the parties or the litigants are relying is also relied by everybody. How
We do
will a
not know,
candidate know?
we do not know everybody. We know
How
only
will a candidate know which book to follow and what not to follow?
that is not my business to see. We do not know how many persons are following this book. Candidate may have purchased this book. He is following. There are so many candidates.
Yes,
And
so
there are
many candidates, so many books.
so many books. If
Yes.
1,000 candidates are there, 500 books are maybe there.
Right.
The 500 books I will consider.
You say this book to read. Let the state government say this book to read.
No, this is not there. This is not there. There. If the state government, if the state government does, that's a different part. If the state government does, it is a different part. But how I can be blamed for that?
How do you blame the students or the candidates for that?
No, I am on the opinion. I am going on the basis of the opinion of the professors.
You engage another professor, you get another answer.
But I do not know.
Yes, that is the reason you in the last matter sought for direction to engage some other expert.
No, at that time,
also
still
not
I'm,
sure.
that is in between court and myself.
Yes,
But
yes.
that is not that I
certainly.
wanted to try. I wanted to try to resolve a problem. That's the
Right.
reason. That's
Right.
the
If
reason.
we are
Otherwise, I
trying to
wanted to
resolve
cooperate with.
problems.
I wanted to cooperate with the court. For that reason, I
Yes,
should not be
yes.
punished by the court.
No, no, not question of punishment. We are all here for finding out resolutions,
Therefore,
nothing else.
if anything is there, lordships can pass the similar order. Let it goes to the commission to decide. But the point is here. But here, this factually it is different. Not that like that case. It is that the preliminary which is there that has been opined by the expert committee same. Factually, it is totally different case altogether. Earlier case,
No, I
preliminary,
understand. I
preliminary order
understand. But
was,
then I was
sorry,
just
preliminary reply was correct, expert committee has changed. And here is the case, preliminary, what is the preliminary that has been kept by the expert?
I can understand this, but then how come these
That is the
study
reason
materials are coming? I do not know.
maybe that is the reason earlier on that day I have cited the judgment.
11 and
But
12.
can I show the judgment, Miller? Other materials will not be taken into
Is the
consideration
state
by the
government
court.
recognizing these books?
Yes, my lord, these books are being taught. Let them say that they do not recognize, they do not know this.
State government recognizes.
Madam, there is a syllabus committee under the West Bengal Board of Secondary Education. Expert body, books will be approved by the government, their number will be there.
See whether this is, please see whether this book is
94.
Oh, yes.
94.
ISBN number is there.
Yeah, please check up.
Page 94.
Yeah, just 95.
Let the state come up with an answer.
Muller, can I say one thing, Muller?
Yes,
Muller,
yes.
on the other day, Muller, I cited one the Supreme Court judgment. If your lordships, I can give it to you again. That
No,
your
no,
lordships
you
has
just
dealt
wait.
with that. And
Just
the
wait.
court, Muller, can I read? Can I read, Muller?
No, I just want to know whether the state is recognizing this book or not.
Okay. I have nothing to say, Muller, on this.
Page 97 or what?
Please come. The petitioners participated in the second
পড়তে পারছি আর কি।
SST for recruitment as assistant teachers. On publication of the preliminary model answer key,
কই?
the petitioners raised objection in respect of a couple of questions.
এখানে নেই।
The objections were considered by the commission and the final answer key has been published. Stop. There is no change in the answer of the preliminary question with the final answer key. Stop.
Wait.
According to the petitioners, they have answered the questions relying on the study material from the book, which is book which has a which has an ISBN number. Stop. It has been submitted that the said book is taught in classes 11 and 12. 11 and 12.
এটা কোনটা?
ঠিক আছে? 11 and 12
এইটাই তো?
in schools sponsored by the state. Now, in the government sponsored / aided schools. Stop paragraph. Have any of you passed the cutoff?
No, mind.
None. All right. As none of the petitioners have obtained
My lord,
the
I stand to be corrected. My lord, the petition number 3, 4, 9, 11, 14 has been called for verification.
all right, who have been called, who have not called, I'm not passing any interim
Yes, ma'am.
order. এই লাইনটা কেটে দিন লিখুন the learned government representing the state respondent is directed to revert with instruction as to whether the books, comma, ISBN number of which is annexed to the writ petition are recognized by the education department of the state, and whether these books are taught in the schools of the government.
My lord, kindly record my one objection that
Yes.
8 persons have not raised any objection, preliminary
All right.
objection.
Learned counsel representing the commission submits that out of the 15 petitioners, 8 of them did not raise any objection. Right? Release the matter for further consideration on 22nd of December.
But I don't know. Please, short period.
Short period. It is your books. Just tell whether these are recognized. What is the short period? The verification process is going on. 31st is the date. Acha, the receipt showing deficit, payment of deficit court fees, and the service be taken on record.
Matter, my lord.
Okay, yes.
Petitioner applied in second
Huh?
SLST
Huh?
recruitment process for assistant teacher in 2025 in class.
Please take the microphone. Somebody is there online.
Petitioner applied, my lord, in this second SLST recruitment process for assistant teacher in 2025 in class 9, 10 and 11, 12, my lord.
Why are 13 petitioners coming together in one writ petition?
Past experience, my lord. They are applying, kindly see, my lord, page number 172. Similar order has passed by your lordship, my lord. Bring effect. Prescribed 10 months to the candidates have been prior teaching experience in aided / sponsored schools under the West Bengal government, my lord.
70 to 11 order.
They are already working in a school outside the state. But
Outside the state.
my lord,
In which place?
Uttar Pradesh,
Which school? Government sponsored, aid,
government person, my lord.
government sponsored school. Why have you come so late?
My lord, there is a confusion.
What confusion?
Confusion is that, my lord. Kindly see, my lord, page number 165. In the rules, and it is also mentioned that at the secondary level in a government and government aided school of government sponsored school, calculate on the basis of 2 marks for each year in service in a subsequent post. And there is but in kindly see in page number 113, when my petitioners applying for their previous qualification, there is only two options for the age relaxation, and the second option, are you working as assistant teacher in any aided sponsored school under West Bengal government? But in the rules, there is no mention about the specific West Bengal government school. There's only mentioned any kind of government sponsored school, my lord.
Where is that? You are working in government schools?
My lord. For
Page?
number
Which page did you show?
page number 35, my lord. Kindly see. Petition number 1, my lord. Anup Roy, petition number 1. School is Harishchandra Intermediate College, Varanasi, my lord.
No. The application form, where is it mentioned that whether you are in any state government school or not? Where? Which page did you rely?
My lord, 165, my lord.
No, 165 is all right, but in the application form,
113, my lord.
113.
113. The application details in, my lord.
Yes.
For the option is, are you working as assistant teacher in any aided or sponsored school under West Bengal?
Yes. So, but
I
then,
am not working in any kind of government aided school in West Bengal, my lord.
right. So you filled in this application form in the month of June.
My lord.
Why are you coming so late?
My lord, there is a confusion, my lord, by the petitioner, my lord, whether they fill the option or not, my lord.
Yes, so let the confusion remain and let the results be published.
But my lord, in the rules, my lord, it is not the mention that it is specific that government aided school under West Bengal have to apply, my lord. It is only mentioned that the any government aided school have to apply for this post, my lord.
All right. Please come.
Page number 172. By the similar matter, my lord, the 10 marks candidate have a prior teacher, and
The
173,
petitioner,
my lord.
where is the court fees?
Paid, my lord. And affidavit service also.
আচ্ছা ওটা রেখে দেবেন and the petitioners claim to be teachers of
Affidavit service kept on.
government schools outside the state of West Bengal. Stop. They participated in the recruitment process for appointment of assistant teachers in second SLST, 2025. They allege that they could not fill up the details of their prior teaching experience as no option was provided in the application form for mentioning the details of teachers who do not teach in aided/sponsored schools under the West Bengal government. As the petitioners have prior teaching experience of teaching outside the state, accordingly, they were unable to fill up the said column. Stop. It has been submitted that the rules pursuant to which the recruitment process is being conducted does not restrict awarding marks on account of prior teaching experience only to the teachers within the state. Stop. The rules clearly mention about prior teaching experience in a government or government aided or government sponsored schools in a substantive post as permanent or on contractual basis. Stop. Paragraph. It is an admitted fact that the result of the written test has already been declared and the interview list has also been published. Stop. The petitioner has approached this court only on 2nd of December 2025.
Right for the 19.
That is long after the aforesaid steps have been taken by the commission.
My lord, not in 11-12, my lord. 11-12 results are not came out, my lord.
The result of 11-12
No,
has
my lord.
written
Only 9 and 10.
written test result has not come.
No, both 19, 11, 12 all have come.
And the interview list has also been published?
Yes.
As per the instruction, my lord, verification is not completed.
9-10 interview list has not yet come. 11-12 interview list has come. Verification has been done. Now the interview has started.
So your client is not giving you proper instruction.
And I have the instruction that not verification is process is still going on, my lord.
All right.
If the verification is proceeds in the interview list, unless preliminary interview list is not there, how there can be verification?
Right. Accordingly, the court is not interfering with the uh, prayer of the petitioners at this stage. Stop. The issue as to whether prior teaching, as to whether marks can be allotted on account of prior teaching experience is already under consideration before this court in several other writ petitions. Stop. Any order passed therein will govern the others also. Stop. In view of the above, the writ petition fails and is hereby dismissed. These to be written with the records.
Eight, my lord, I am for the petitioner. Matter relates to, my lord, higher scale of pay. Petitioner, my lord, appointed as a BCom in a particular school in 2007, and he asked for, my lord, his affidavit of service. Page 34 is
Who
the,
is your other side?
my lord, what is happening? Page 34 is the
Other side?
other side, my lord. I have served.
When did you serve?
My lord, the last week, my lord, your lordship upgraded that I have served the notice to the DI as well as the government with the
You did.
matter was pending before, my lord, adjudication of the larger bench.
Where is the service upon you have posted to the learned government pleader?
Government pleaders refused to take because 2023 matters.
What do you mean to say?
They refused to take in hand. Since the time is over, they are not in a position to receive in hand,
Survey copy.
as your lordship.
Let a copy of the writ petition be served in the office of the learned government pleader. তার আগে একটা line লিখুন। The petitioner seeks higher scale of pay. Stop. The presence of the state respondent is extremely essential for effective adjudication of the instant writ petition. Stop. It has been submitted that the office of the government pleader has not accepted the copy of the writ petition.
Since it is 2023.
As the matter relates to the year 2023. Right? এবারে হবে ওইটা serve released on 5th January 2026.
My lord, before, my lord, kindly. Next Thursday, my lord, I will. My lord, first time. This is
Yes,
first time.
yes. Let it come. Why
ca-
are you so much of hurry? Pending from 23 and now all on a
My lord,
sudden
I know, my lord, is going to
the
be retired very
emergency
soon.
cropped up.
Retired very
No,
soon.
for
that
2
is-
years you didn't take steps. Next.
I'm there.
Nine. Item 9. Item 9.
Yes, but I'm for the commission. That I am for the petitioner in this matter. বাকিগুলো reason order আছে কি আছে দেখ। My lord, this is the matter for extension of validity of the recommendation in respect of upper primary selection process. My lord, petitioner is a job loser in respect of first SLST. My lord, parallelly petitioner participated in the first SLST in respect of upper primary selection process. But upper primary selection process, a panel of 14,052 candidates has been published by an order passed by the Honorable Division Bench presided over by Justice Chakraborty in the month of, my lord, August 2024. And first.
1 minute. Let me hear the commission stand.
Yes.
What is your stand?
Reason order is I'm praying for setting aside the reason order. This is the second time, but I have made a prayer for extension of validity of recommendation, and I may join that particular school. But they have, my lord, first round of litigation honorable court directed to consider, since, my lord, they have the power to, my lord, validated the recommendation up to 150 days. That period, my lord, I made a representation. They have negated my claim that the job losing is not an important factor. So, my lord, they are turned down, my lord. So, I am praying that setting aside that order. My lord, on the other hand, my lord, division bench recently held, my lord, that job losing is an important batch of matter who have even not participated in counseling.
Show me that order.
Yes, they have devarying. There is specific bar for further counseling. That honorable division bench held. No, you conducted further counseling in respect of upper price, this selection process. This matter, this petitioner appointed and recommended.
Orpita Pramanik is being
Yes,
relied.
ma'am.
Orpita Pramanik is being relied.
Yes.
My lord, unless my friend shows me, it is very difficult for me to catch up with what he is saying. Firstly, he is saying that in the recent order we have said that job losing is not an important factor. But job losing has not been dealt with.
Yes, yes.
It has only been mentioned that he was a candidate of 2016. The petitioner therefore informed about his inability to join after 103 days, that is after expiry of 90 days. Cited above mentioned reason as a ground for inability to join, that loss of job. I presume that is the
Where
loss
are
of
you
job.
reading from?
I'm reading page 26, the reasoned order, which is under challenge.
Right?
The middle paragraph I'm reading, the big
Yes.
paragraph.
Yes.
His ground for seeking extension
Was
he was already working as an assistant teacher of history for classes 9-10 in connection with first SLST 2016,
Hmm.
and hence was a
And there was a legal
and there was
process.
a legal process in Supreme Court. The petitioner therefore, number one, informed about his inability to join after 103 days. That is after expiry of 90 days. Two, cited above reason as a ground for such inability to join. His prayer was rejected because in sub-rule 3 of Rule 17, the West Bengal School Service Commission selection for appointment to the post of teachers, etc., whereby the commission may extend the validity of the recommendation beyond the period of 90 days for any reasonable cause, for which the reasons to be recorded in writing, extending the period of validity of such recommendation letter for further period not exceeding 60 days. Moreover, total 150 days from that date of recommendation is exceeded. In view of the fact that the ground of his prayer cannot be considered as reasonable cause, simply because the entire selection process got set aside. Thousands of candidates became job losers. They can all of them cannot come back into this selection process. Supreme Court also did not give any such observation that those who have participated in a selection process but have not yet been selected can come back and rejoin. Supreme Court has given lots of relief to the job losers, but this type of relief was not given. If you were working previously, you can go back to your previous employment. But this kind that you can go back and disturb or rather disrupt an ongoing selection process by coming in midway, that the Supreme Court did not allow. Now you were called for counseling. There was no bar. You could have come. You could have accepted your recommendation letter. You could have sat for 90 days after getting it. You could have asked for 60 days extension within the 90 days, before expiry of 90 days, or even after maybe. But you just sat tight. You were confident when you had actually lost your jobs much earlier, pursuant to the direction of the division bench of our court. It was their jobs were already gone. It was only the appeal which was being heard, and they were enjoying a stay. Hundreds of candidates we have extended, but just simply because I was a job loser, I was sitting tight. This we are opposing. The judgment.
How many vacancies are still there?
My lord, firstly, the panel has expired. We have concluded 8 rounds of counseling. That is more or less the end of the selection process. Now, the court had directed us to recommend 14,052 candidates. So candidates, I think 1,242 candidates got left out, for which we were facing, or we are still facing, contempt, which is fixed on Monday. Court has given a direction, the Honorable Court has given a direction that you talk with the state and you get that 1,242 vacancies from the state government.
Filled up.
Yes. No, I require the vacancies.
Oh,
So
you
state will
still
give me
require
1,242 vacancies. And
14,052 vacancies filled up.
no, we had 5,000 leftover vacancies which were not matching with any of the leftover candidates.
All
So
right.
we had 1,242 leftover candidates, 5,000 vacancies not matching.
Right.
In the contempt proceeding, the Honorable Division Bench told us that very well, you sit with the state government will give you
Matching
the
vacancies.
matching vacancies, and equal number of your 5,000 you will return, so that the total number of vacancies with the state remain unaltered. So that is fixed on Monday. That will be heard on Monday, the contempt
No,
proceeding.
that is all right.
Yes.
But then, assuming the direction that was given earlier shall be this consideration of their participation shall be subject to available of matching vacancies.
Yes.
If with a rider, the prayer of the petitioners, whether can be allowed or not.
My lord, this order was passed with regard to absentee candidates. This is not a case of an absentee candidate. This is the case of a candidate who was recommended.
Refused.
Yes.
Not refused.
He refused.
But now he is wanting it. So that refusal is withdrawn.
Right. Initially refused and now.
So if each candidate creates this kind of a chaos, I choose a school, I block it, I cannot show it in the next phase of counseling. Then suddenly I come back and I say I want it.
Right.
Now, not just one candidate, 20 matters are before the court. There are many other matters also, maybe not before the court, but they will come the moment this arises. Possibly. I'm not saying it will happen. So keeping all these things in mind, now court, what has the court said, or the division bench has allowed with regard to the absentee candidates, that okay, very well. The single bench had also given the same orders, that subject to the availability of the vacancy. So at best, what might happen? Out of all the candidates, already in that category, we have over 60 candidates already who are enjoying that order. So those candidates, we will show them whatever vacancies we have left after the entire court has also made it clear after completion of this 1242. So first we will comply with the order as directed originally in the contempt. Then the court has said that for the absentee candidates, okay, very well, you will call them for counseling subject to the available matching vacancies. So my speculation again here would be that maybe 4 or 5 vacancies at the most they might.
There are no vacancies.
No relief.
Do not get a chance.
Yes.
Vacancy.
Yes, but widening the scope when there are no vacancies, that is also not really justifiable.
I understand, but then keeping in mind the situation that has cropped up since the petitioner has participated in a selection test and qualified, you've recommended, he was engaged somewhere else, now job loser, trying to come back.
Moreover, I have seen higher marks.
Moreover,
merit.
now no merit. You've chosen to give up your merit. Had you been so meritorious, you could have come over here. That you chose not to. Only keeping these things in mind if something can be done, provided there are vacancies available.
The vacancy, the correct vacancy position, here and now, I cannot give it.
I understand.
Because what will be the outcome of the 1242? Upon that, it will depend that what I have left and whether they will match. And Then may I just pray for one thing, because there are 20 matters. Each matter, the statistics are different. All of them have not come up against reasoned orders, possibly.
Yes, yes,
All of them.
Or what except
Oh. Yes, so I checked the second matter.
except by the 10 is the first time or all other
Yes,
matters reasoned?
yes. So I checked the first two matters. The second matter did not have a reasoned order. Then how long after they came? These things are to be taken into consideration.
No,
Let
but
me-
why will the delay in approaching the court be looked into in
No,
that
I'm not
way?
looking at the delay in approaching the court. I'm looking at the delay in approaching the authority for extension. Because we have followed a particular pattern while rejecting or allowing. Those who have given their orders, given proper reasons, my learned friend is also well aware of it, that those candidates we have allowed, even after 90 days, one case my learned friend often cites, she was carrying twins, the candidate, and they had to be surgically aborted. So her condition was very critical, and still within 3 days of expiry of 90 days, she wrote to the commission during the period of her bed rest. So these candidates we are allowing.
Genuine candidates you all are allowing. It's all
Yes.
right. But then see if anything can be done with these candidates also.
Let me cross-check the various orders which have also been passed, and let
Because
me come back.
last occasion the matter was adjourned at your instance only.
Yes, yes, this
20
matter I have discussed, but the remaining matters, there are 20 matters today before the court. Let me come back on a subsequent date. Give a short date. I don't require a long
Mhm.
time.
Mm.
Subject to the convenience on the court, it can be on Monday, Tuesday, any day.
Where will Tuesday in that case? Please come.
একটা রিজন অর্ডার করি না ডিসিশন
The
দুটো তো ডিসিশন হয়
আচ্ছা।
the petitioner prays for a direction upon the commission to extend the period of validity of the recommendation letter. Stuff. The petitioner was serving in a school but lost the job in view of the order passed by the Honorable Supreme Court. Stop. The petitioner, now while the petitioner was in service, the commission issued a recommendation letter in his favor. দেখে নেবেন কোনটা his আর কোনটা her হবে। In his favor, recommending him to a different school in respect of a different selection process. Stuff. Initially, the petitioner was not inclined to accept such recommendation. But after he lost the job, the petitioner intends to fall back upon the said recommendation letter. Paragraph. Learned advocate representing the commission submits that at present matching vacancies may not be available where the petitioner can be recommended. Stuff. The petitioner did not seek extension of the recommendation letter within the stipulated time period. The commission has rejected the prayer for extending the recommendation. Stuff. Next. Upon hearing the parties, it appears that the petitioner took a very calculated stand and did not act in accordance with the recommendation letter. Full stop hobe na, and permitted the same to expire. Stop. At this stage, keeping in mind the jobless condition of the petitioner, the commission may take a sympathetic stand and consider extension of the recommendation letter provided matching vacancies are available. Stop. To allow the learned advocate representing the commission to revert with instruction, release the matter for further consideration on 9th December 2025.
It's not the experience which is not being counted. It is the result. Because I have already
Matter is slightly different.
participated and completed my
Next matter,
course.
my lord, it is the first time appearing. Commission has not taken any decision.
Now,
Even,
the
my
next
lord,
page,
petitioner-
When did
in
it
view of the
expire?
statement
Yes,
made
my
on
lord,
behalf of the
before
board,
expiry of the recommendation, petitioner made a representation before.
Show me that.
Yes, yes. My lord, kindly see the recommendation letter, page 18. It is issued, recommendation memo issued on 20th November 2024.
yes,
My lord, got it? And my lord,
on behalf of the board and without any
thereafter, my
further
lord,
consideration,
on
the writ
26
petition was
December
allowed and disposed
2024,
following
prayer
direction.
within before
My
the
lord, I have
my lord,
placed that
cancellation of
particular
the job,
order, my
petitioner
lord.
made a prayer
That order, my
I
lord, I have
recommend
given to your
within
lordship,
90
and I'm
days
skipping over that
stipulated
part.
period, my lord, petitioner
On
made a prayer, my
29/9/2022,
recommendation
the date on which
extended
the
that I
learned
may join
single
the
judge
school.
allowed the writ petition,
That,
the
my
board
lord, in
issued a
juncture, my lord,
notification
previous
indicating that the
honorable
result
bench, my
of the
lord, passed
DLAD
several
Part 1
order and passed the
examination held
mandatory
in the
order
month of
one,
July
my lord, one I am
for
showing,
session
that one Najma Molli.
2020-2022 is published. And in
My lord,
terms of the
since they
said
have approached
notification, the
within 90
candidates were
days, they
allowed
are
to avail
their candidature to be
post-publication
considered.
review or
This is
scrutiny
direct-
of their
See,
performance
your letter
within the prescribed time.
mentions
The publication
only
of the result
about
was also intimated to
validity,
the various
extension
institutions,
of
and the
validity
students were
for a
permitted to
period of
receive the
90
digital
days.
mark
That
sheets.
90 days has
The exercise
expired.
was intended
How
to
can you
enable
seek
the
extension
applicants
now?
to candidates to participate
this stage.
in the
Yes.
recruitment
My lord, but
process
I made a
on the
prayer within
same
90
day
days.
on
So what?
29/9/2022.
So what? It has
Yet
to be
another
taken that
notification
assuming it was considered
was issued
and allowed,
indicating that the board
you
is
could
going
have
to
got
recruit
at
TET
best
qualified
90 days.
candidates for
Now
appointment to
that
the
period
post
is
of
also
assistant
over.
teacher
But my
in
lord,
the
ratio
vacancies
of the, my
that
lord,
may
Ratio,
be
forget
indicated.
ratio.
My lord, I could
Now
have,
you
let
The
take a decision. My lord, let
intendment
observe
of
the
this
same and let take a
notification is
decision.
in
you
the
have
clarification
approached
and
this court in
declaration
August.
that
It is
candidates
not
like
that
appellants
you
who were
came
TET
within the
qualified
90
and
days
had
validity
undergone
period.
No, no.
DLED
Neither did
training
you
and
come within the
qualified for the
150 days
Part 1
validity period.
examination
But
can
prayer is
participate in the
within 90 days.
recruitment
My lord,
process.
observe the same. My lord,
It
since
was
it is the
also
first time,
indicated that the
let the
recruitment
authority take a
notification
step.
and application
Since it is
form
undecided.
will be
No, no,
made
that
available on
I'm
the
objecting
website
to
with the
because
effect
the
from
rule
21st
it
October
states that if
2022.
I extend after
As
consideration
it was
of the
contended by the
representation,
respondents and the
I am to give
acceptance of the
reasons in
High Court
writing.
that this
If you
notification dated
extend,
If I extend.
you can always
29/9/2022
refuse.
If
itself
I
is the
reject, I
recruitment
am not under
notification
any
in order to
obligation to
contrast
consider,
it
pass
with
an
the
order of
subsequently
rejection
issued
and
actual
intimate
recruitment
its
notification
effectiveness.
dated
Only those who get
21
extension, they are
October
to be considered. That is the rule.
They have to be
2022.
considered.
Only there, only for them the reasoned order is to be passed, not for those who I reject.
No, then that
Normally
is
the opposite of what
that
we.
that is a very bad proposition.
But that is
Because
the
the
rule.
moment
That is the rule.
you cannot do that.
That is the
One
rule.
line order is enough. That you applied beyond the period of validity, you can reject it. That line is enough. Why will
Then I
it have, what is the requirement of passing such a reasoned order?
If I reject in that manner,
Right.
then I will have to also give a reason.
Yes.
Reasons are not always restricted
Limitation.
to the date. Reasons are not always restricted to the date.
Then that is
Reason
something
of
different.
rejection is also with regard to the reason given by the candidate is not acceptable.
Yes.
Like here, no reason is given at all actually in this.
No, he has mentioned some family issues.
we have reproduced both of them. Notification of this, the notification has been given, Lord, where the vacancies were also declared. So, Lord, I'm skipping over this part. Lord, why I'm placing this judgment, Lord, as a whole, because that answers the questions of Mr. Shannal. Mr. Shannal, which has taken, Lord, a plea of cut-off marks, cut-off date, Lord, and says, Lord, on the date of notification, we must post the requisite qualification. This was also being argued before the Honorable Supreme Court. The same argument was advanced by Mr. Shannal, but that was negated, and the court, Lord, held otherwise. Because that is the reason, Lord, I've shown your Lordship in paragraph 3 that the Honorable Supreme Court was aware that the recruitment rules has been amended and subsequently amended rules has been incorporated. Based on that, also this view came. That is the reason, Lord, I'm placing the judgment as a whole. Lord, that answers everything. Now, kindly excuse me for a second, Lord. Following the above referred notification, the recruitment notification was in fact issued on 21/10/2022, which is in our case, Lord, the subsequent notification in November, 19th November. The board in its submission before the division bench contrasted the previous notification dated 29/9/2022 with the recruitment notification dated 21/10/2022 and asserted that the latter alone is the recruitment notification. The recruitment notification dated 21/10/2022 is reproduced for ready reference. So, on the last occasion also, in previous recruitment, we have also said that the subsequent notification, which is 19/11/2025, is the last notification for recruitment. But now today in court, the board comes and says, no, the September notification is the recruitment notification. This has also been clarified, that the board cannot take these different turns. But I'm skipping over the notification because this is akin to, Lord, the November 11, 2025 Lord, notification. Now, paragraph 14, Lord, it is clear from the above referred notification dated 21st October 2022 that 1, it invites online application for recruitment to the post of assistant teachers. 2, it also specifies that TET qualified trained candidate, including the appearing candidates for the sessions 2022 in DLED, special B.Ed course will be eligible for participation. 3, it mentions that there are 11,765 vacancies and further notifies that the recruitment shall take place under Recruitment Rules 2016. With this analysis, there cannot be any doubt about 21/10/2022 being the recruitment notification. This controversy must end here. So that's the finding with regard to what would be the notification, recruitment notification. The appellants applied as per the recruitment notification dated 21st October 2022 obtained their course completion certificate on 29/11/2022. And the final result of part 2 of the examination were also declared on 30th December 2022. Interviews commenced in December 2022 and the process was moving towards completion. At this stage, questioning the legality of the order passed by the single judge, the private respondent who possessed DLED qualification as on the date of recruitment notification dated 29/9/2022 filed writ petition, the earlier notification. This is the submission of, akin to the submission of the applicants who have filed the CAN application. I am not giving you any answer. I am submitting before the court.
Yes. Yes.
Now, my lord, before the division bench of the High Court contending that the appellants are ineligible and their candidature must be rejected. The primary contention was that the appellants did not possess the minimum qualification as of the date of recruitment notification and that the board could not have relaxed the recruitment rules permitting the appellants to participate in the recruitment process. The division bench of the High Court, by its order dated 27/2/2023, asks the board to file an affidavit indicating the circumstances in which the recruitment process was initiated, as well as the steps taken by the board in conducting 2022-2022 DLAD course. In compliance with the High Court's order, the board filed an affidavit. The relevant portion of the affidavit is as follows. My lord, may I just, Lord, read the relevant portion, Lord? Now, this has been quoted later on, so Lord, I'll place from there. But your Lordship would kindly continue, Lord, with paragraph 17. Finally, the order impugned before us, the division bench of the High Court, allowed the appeal and set aside the order of the single bench. The solitary factor that impressed the High Court is simply that, as Rule 6.2 of the Recruitment Rules 2016, as amended in 22nd of December 2020, unambiguously specified the eligibility qualification required as on the date of advertisement. Candidates must possess the eligibility qualification as of the date of the advertisement, 29/9/2022. Firstly, the High Court treated the date of notification dated 29/9/2022 instead of recruitment notification dated 21st October 2022 as the recruitment notification, and secondly, it construed the rule to have prescribed a cut-off date for qualification. In this view of the matter, the division bench proceeded to set aside the later part of clause 3b of the notification dated 29/9/2022, enabling candidates like appellants to participate in the selection process, virtually holding all the appellants ineligible for even participating in the selection process. Lord, the order, Lord, of the Honorable Division Bench was also, Lord, quoted. Having heard the parties and considering the materials placed, this court is of the clear view that the board cannot travel beyond its own recruitment rules. Apropos, the above discussion in 2016 recruitment rules as amended by the notification dated 22nd December 2022 unambiguously specifies the eligibility qualification requires as on the date of the advertisement. The nature of such qualification is also specified by the NCT notification dated 23rd August 2010. The court further notices that the law is well settled on the point which stand also discussed above, that the eligibility qualification must be possessed by any candidate on the date of recruitment notification. It is undisputed that the private respondent in MAT such and such and MAT such and such acquired the minimum eligibility condition of DLED on 29th November 2022, much after the publication of the recruitment notification of 29 September 2022. In view of such the position, the board could not have created room for the private respondent. This was the observation, saying this, that Lord, the room was extended to them because and considering the first notification as a recruitment notification. This observation was not struck down by the Honorable Supreme Court and said the subsequent notification is to be read as a recruitment notification. Now, Lord,
first date of the notification, which
here, Lord, is 25/9/2025. And the second one is 19/11/2025.
Okay. Yes.
Challenging the judgment and order passed by the division bench, appellant filed present appeal. We have heard Mr. P. such and such, such and such, such and such, and also Mr. such and such. And for the board, Mr. Shannal and learned senior counsel for the respondent, and then now the observation is we may mention at this very stage that we have informed all the learned counsel appearing for the persons who have filed impediment a petition that we will not be entertaining these applications, but would allow them to withdraw and avail. Some candidates also wanted to join the cause, and that was the reason. Now, Lord, the interpretation, Lord, paragraph 19, Lord, in interpreting, Lord, the rule, interpretation of Rule 6.2 of the West Bengal School Teachers Recruitment Rules 2016, NCT is the statutory regulator for teachers' education. In exercise of its power under Section 32 of the NCT Act, it makes regulations specifying norms, standards, and guidelines. Inter alia prescribed minimum qualifications, and one such exercise in the prescription of minimum qualifications for teachers under notification dated 29/7/2011. The West Bengal School Teachers Recruitment Rules 2016 by itself does not prescribe a minimum educational qualification for teachers. Instead, though Rule 6 of the Recruitment Rules 2016, it incorporates the minimum qualification as prescribed by NCT norms from time to time, Rule 6.2 of the Recruitment Rules 2016 is intended to be incorporate NCT qualification that is relevant as on the date of recruitment, and as such, the provision had to be worded flexibly to accommodate changes that may be brought about by the NCT from time to time. In order to ensure a seamless adoption of amendments, modification, or variations prescribed by NCT from time to time, the rule adopts the standard legislative device or simply incorporating and referring to the minimum qualification as prescribed by NCT. Further, to ensure that the latest prescription of NCT should be made applicable for any recruitment, the rule also provides that qualification prescribed by NCT prevailing as on the date of publication of the recruitment notification must be possessed by the candidate. The intendment of Rule 6.2 of the Recruitment Rules 2016 is only to declare that the qualification as prescribed by the NCT and that are prevailing on the date of publication of the recruitment notice should be possessed by the candidate. The purpose and object of this rule is not at all to declare a cut-off date for obtaining qualification. We are in complete agreement that the clear stand taken by the board in its affidavit filed before the division bench of the High Court, in which the board clarified the position as under. The aforesaid notification dated 29/7/2011 laid down the minimum qualification for a person to be eligible for appointment as a teacher. The notification never stipulates any date of eligibility. In other words, and on and from which date such eligibility is to be counted and assessed is not specified in the notification. It can be the first day of January of the year of recruitment, it can be on the date of recruitment notification, or it can be the date of which the candidates is evaluated. At the cost of proximity, it is stated that the
due to my family problem and other related issues.
Yes.
A very vague one.
Yes, very
13.
13,000 as
And it will come down to 48.
48,000. As that, my lord, by which these transfers are made, my lord, they should be of the same body.
There are 76.
Suppose, my lord, the bodies are different. Where this, my lord, the petitioner is working in Calcutta, and the body of that in Malda, they are different. My lord, I have indicated that.
In that case, can the state find out a suitable vacancy where the petitioner can be accommodated?
Lordship, I have received one.
What does the report say? Give a copy to the petitioner also so that he also gets to see.
At paragraph 3, Lordship.
Mm.
Special rules. এটা আমি নিয়ে এসেছি rules টা। হ্যাঁ, founder body আলাদা।
See, it is the
The mere technique.
Archbishop of Calcutta and the Archbishop of Malda. This is the difference.
Nothing. The technical.
Will this be such a factor that the petitioner cannot be accommodated?
My lord, the rules, my lord, kindly sees.
Rule 12.
Rule 12. My lord, may I hand over?
Yes. No,
Okay,
it is
my lord,
mentioned over here. It is mentioned. Sub rule 1 of 12.
In this case,
Any sanctioned post may be filled up by way of transfer, holding the same region and run by the same governing body, founder body. Mm. Where are the, suppose, assuming that the petitioner cannot be transferred to this school, do you have any other matching suitable vacancy where the petitioner can be transferred? Because the petitioner is in trouble, she has an autistic child, and a sympathetic view has to be taken.
Everything has been
even she says, whatever the study.
no, no.
See, 1,13,000 coming down to 48, less than even half the lady is willing to accept.
but probably there will be difficulty in
I could say, my lord, in
because
disability.
the bodies are different.
How much will it be difficult?
Own school, own
My
choice.
lord, my lord, though I am not appearing for the, my lord,
State.
district and state in this
Yes.
matter, my lord, the difficulty I have got from other, my lord, DI, that there will be a difficulty in accommodating the preparing of the service books and everything, because my lord, she's my lord, serving in a particular post. My lord, she was appointed in that particular post. She is, my lord, all the scale of pay and everything has been adjusted in that fashion.
Now
Now-
you have to readjust. She is voluntarily giving up. She is surrendering her right.
Voluntarily wants to. And
My lord,
my
the-
client is present, directly taking instruction.
Find out a way as to how she can be accommodated over here. Whatever is required to be done, please do it.
মালদা ডিস্ট্রিক্ট ডিআই কেও পার্টি অ্যাড করে দিতে হবে
Okay.
let them add
My lord, whether these school where my lord, learned friend's client is my lord, working, whether that school has another my lord, set
she
set of
wants to go there.
no that maybe there is a school in Malda also run by the same governing body, my lord, that can be found out.
No, there is no.
Had there been so, she would have gone there.
That is the difficulty, my lord.
And these minority institutions, the name appears to be same,
Yes.
but then they are not from the same body.
No. Actually, Mala, there is a fraction. Nothing is actually the body is the same. There is a fraction. The law.
But now this fraction is creating problem. Find out an alternative as to how this
my
lady can be
May
accommodated.
I indicate one thing, my lord, because of that, my lord, it is postulate from the Disability Act, my lord. I want to, my lord, canvass one section of the Disability Act, that is central legislature. And in the line of that central legislation, the central government passed such notification, my lord. I just read, my lord, one
Yes,
section,
Keith.
section 31 of the, pardon me, because it
Yes.
is in my, just I read it. Section 31, free education for children with benchmark disability.
Hmm.
Notwithstanding anything contained in the Right of Children to Free and Compulsory Education Act 2009, every child with benchmark disability between the age of 6 to 18 years, because of that, my lord, in Right to Education Act, there is 6 to 14. But in this type of special child, their right 6 to 18 years shall have the right to free education in neighborhood school or in a special school of his choice. So there is two types of school. That is this child for the this all for the beneficial of this child.
And in this line, my lord, the central government passed several notification to accommodate the parental transfer, my lord. And in this regard, my lord, the central government notification is also there. But
No, but then this is not central government. The
yes,
lady.
yes, but my thing is that, my lord,
The state government, my lord.
No, doesn't matter. 1 minute. The lady stays in Malda.
no, my lady stays in Kolkata, but the father and the family stays in Malda. And the child is such a violence because of that, this type of, she can't, my lord, by single-handedly can't.
So the lady has to go back to Malda. If somewhere the lady can be accommodated.
That's the problem.
DI Malda is a party in the writ petition. Yes, leave was granted and Malda has been added. All right. You take a note. DI Malda is the respondent number 8. The school and the headmaster are respondent numbers 9 and 10. Right. So you take instruction from DI Malda without any delay as to how this teacher can be accommodated, where she is to be accommodated, and whatever is required to be done. Followed? I'll mention it in the order sheet. Please come.
May I hand up the government notification regarding?
You keep it with you. I do not want the notification.
It is 9 and 10.
Learned advocate representing Rohutara St. Thomas High School within bracket HS. Produces a write-up, a report from the headmaster of the school signed on 1st December 2025, mentioning the difference between the scale of pay of a past-graduate teacher and a postgraduate teacher. Stop. The petitioner, who is currently enjoying the postgraduate scale of pay, is agreeable to accept the graduate scale, the pass scale of pay, as she is urgently required to relocate to Malda for taking care of her child who has special needs. Stop. The report of the headmaster also submits that the founder body of the Rohutara school is different from the founder body of the Kolkata school, where the petitioner is currently teaching. Stop paragraph. As the the district inspector of schools is directed to consider the instant case as a special one, keeping in mind the special need of a minor female child.
Male child.
And
male child.
আচ্ছা male child, তাহলে minor child করে দিন, minor child and locate an appropriate vacancy where the petitioner may be appointed. Stop. Release the matter on 10th December
Only child.
The report by the District Inspector of Schools, Secondary Education, Malda, signed on 28th of November 2025, be retained with the records. You can ask your client to join. এটা লিখে দিন তো, the District Inspector of Schools, Malda, Secondary Education, Malda, is directed to remain virtually present on 10th December when the matter will be taken up for consideration by the court.
My lord, the interim order will continue. My lord, we have
Yes,
Order dated.
the interim order. Directing the Rohutara school not to finalize the recruitment process till the disposal of the writ petition shall remain in force. It is still disposal, so it is
Yes.
already there. I
So-
again made it clear.
Chakraborty is appearing in this matter, my lord.
Plan for the
He's
commission.
suffering from conjunctivitis, my lord. I'm instructed to, my lord, seek accommodation for a week.
All right, and accommodation has been sought for on behalf of the learned advocate representing the petitioners on such prayer released on 5th January 2026.
Great.
I'm for the petitioner, Malad. This is that matter, Malad. The whether the matter is to be heard in the High Court or the SAT, Malad.
Oh.
AG appeared.
Right,
Because it will
Next
take
week.
some time. but-
January. Let the matter appear in the list.
but
And-
they will-
Next week.
next.
Release the matter on 16th of December.
The advocate, learned advocate general is also engaged.
Yes, yes.
You want to have?
33 minute I appear. কোথায় গেল রে? শান্তনু ছিল তো? Well, I'm for the petitioner. তুমি বলে দাও। মানে it is the case of reassessment of the answer script in a higher secondary candidate in respect of the Google and history. Education. Education. Geography and education. Well, I've checked up the judgment, all are against me. That the evaluation is not permissible. But if the court satisfied, no, there are some illegality, irregularity, then my lord, one of the judgment says that the read court can exercise his power. But that judgment I shall be placing before that. What is the illegality? Why I am coming before this court? If the one number is added, she will be in the the 10th positions. Up to 10th, these are the merit list, 10th standard. If the one number is added, he will. That is the only reason. Otherwise, for 1 or 2 or 3 numbers, nothing will happen.
It will happen. It matters a lot. Even fractions matter.
Anyhow, I was wondering why are you so
No.
because the one well he said, and my lord, I was convinced that categorical statement was there that only to deprive her claim that she could not come within the zone of 10th. But this step was taken. And answer script, each and every reply, there was cut in the cut marks, initial marks was given 6, thereafter it was reduced 5, not only one, each and every answers. If your lordships kindly consider this aspect of the matter. Thereafter I said place one judgment.
Show the answer script.
Yes, yes. Reasoning was there.
Reasoning?
Yes.
All right,
Although
let him show first.
there are some
Let him show.
page 77, your lordships kindly have a look. Question of 77. Total বলবো দিয়ে, okay. Page 77, 3A. This is the question, 3A. Right? Your lordships kindly have a look to this 3A question paper.
3A
A.
has got 7 marks. 6
Yes,
plus 1.
6 plus 1. Now your
Describe
lordships
what
kindly
is
reply.
superimposed drainage. 3 landforms produced
Now,
by the
now my lord, the reply, page 84. 3A, it has been started, page 84 top. 3A, 1, 2, 3, 4, 3 per 3, it will be counted 2 into 3, 6 marks. 6 marks. Now, my
No,
lord, the,
1 minute. 3A means 84.
yes,
84, 1.
my lord, minimum
3.
three numbers, 3 answers are required to be taken into considerations. So show 3A, 1, 2,
and 3.
and 3.
Yes.
As of 4 was also there, but the 3 will be taken up. 3 into 2, 6.
All right.
Now your lordships kindly see the 4 remark portions.
Remark portion.
Portions 86.
হ্যাঁ চিত্রের উপস্থাপন ঠিক হয়নি
ঠিক হয়নি This is the remark, চিত্রের উপস্থাপন ঠিক হয়নি. Now my lord, the marks initially was given. Initially 4 half plus 5 and first 6. Thereafter 4 and half and 5. And ultimately 5 was given. Thereafter, my lord says kindly see the below portions. আচ্ছা একে এক কত 5 marks were 3C, page 92, 96. Question number 3C. 92. Question number 3C. Question number 3C. দেখে না it starts from page 89. PC তো
89
page 89 starts 3C. My lord, all are correct, and my lord, and marks calculation was 92.
92
page. And page number 92.
Prior to that, your lordship kindly takes page 91.
আমি বলছি তো তুমি চান্স
ওটা দেখাচ্ছ না তো তুমি
তো তুমি দেখানোর চান্স পাবে না
92
92
3 plus 1 plus 1.
Yes, 3 plus 1 plus 1. Initially 4 plus 1. Then my lord 5 and half, 5 and half. Thereafter 3, 1, 1, 2, 5, 6. Ultimately 5.
See, whatever the examiner has given.
No, not only one. I am not, I have, that's why I purely submitted. Not only one question. Now your lordships kindly see. Page 78. Page 78 is the question. Page 78 is the question. Below portion C. The state one characteristics of planning region discussed with the problem associated with the overpopulation in different countries in the world.
Answer 96.
Answer is 96.
How come the questions are in English and the answer are in Bengali?
There are 2 versions. 2 versions are there.
So Bengali questions are
Also there.
You have annexed the English ones.
Yes.
Yes.
Now 96. E. Petitioner given the answer 96 E.
And example given 7 examples.
6. Given the 6 example.
See, given this example, why if 3 has been given and not 4, can the court look into this?
Page, page starts from E1, page 96.
Given 6 example for 6.
E. You also got it? E.
Yes.
1, 2, 3,
Right.
4, 5, 6.
Yes.
Up to 6. The example was given up to 7. Now, your lordships kindly. Page 99. The remark of the examiner, উদাহরণ সহ উত্তর দেওয়া হয়নি. There was no such. মানে the model answer যে উদাহরণ সহ উত্তর, মানে the remark was উদাহরণ সহ উত্তর দেওয়া হয়. তারপর কোথায় হচ্ছে?
96 এই জায়গাটা উপর portion.
And page, if your lordships kindly see the 99 page top.
Initially, marks was given 68.
Initially, the marks was given 68. Now, your lordships kindly say next page, page 100, 66.
No answer was given by the petitioner.
And the no answer was given by the petitioner on that day. Now, your lordships kindly see the caging portions, page 79. Page 79, if your lordships kindly have a look. There are multiple corrections in the caging portions. Initially, it was given 68, then 66. Statement about ওইটা কোনটা আছে জিওগ্রাফি একটা না না ওটা তো হলো না যে আরেকটা এডুকেশন এটা না এটা
See, possibly the questions are first checked by one teacher and thereafter again checked by another, and that is the reason this has happened. And it happens in each and every students.
Each and every questions, and there is a great doubt whether it was correctly afterwards.
There is no scope. You have to rely upon that authority.
No, because of the fact, my lord, I only real lordships kindly the other, or I started my argument that the all judgments are, my lord, the paragraph 20 paragraph তুমি বলেছো সাইটেশনটা তুমি অনেক ভালো দিয়েছো আছে নাম বলতে কি আছে অসুবিধা 2019-16 SCC. Your lordships kindly have a look to this para 20 and 21. 2019-16 SCC. যেটা দেখিয়েছে হ্যাঁ 60 model answer. Babu and Anna. Babu. I could
Yes.
Now, your lordship, I'll finish page 30, the education subject, page 30, if your lordship kindly, page 30. Define central tendency, find out the mode from the following frequency distribution. This is the page 30, the question. Now, the answer is page 40, 40. Answer is page 40, your lordship got it. Answer is correct, but the examiner's observation short method. Initially it was given 6. Thereafter প্রতিটি step পড়লে পুরো নাম্বার দেওয়া যেত. Now your lordship kindly see the model answer page 60. C. Give full marks to the proper definition of the central tendency. Give full marks to the correct calculation of the mode. For proper arrangement of the table with class boundary, you may give 1 mark answer mode 5 to 9.5. Now your lordship answer is correct, but short method. We do not know what is the short method or long method. In a model answer, there is no such indication. Well, I have pointed out these are the only one and categorical statement was made in paragraph 9.
Yes, what is your submission?
Your lordship has seen the Milord answers to the questions papers. The model question paper and answers they are referring to, that is not the benchmark. The way and the parameters in which the examiners are assessing the answer scripts, that creates the benchmark. We don't treat the model answer as a
Who has published this model answer? You?
no.
Oh, it's by some other body?
Chaya proportioning and other things.
Some other body.
And if your lordship kindly sees the answer, each and every answer where some corrections are made, ample reasoning was there. Reasoning was there. And
What is the system? One teacher corrects or there are two? First one and thereafter somebody else rechecks.
corrects, thereafter goes to the head examiner.
She rechecks. So there is two.
And he applied for in terms of regulation 21 sub-regulation 6, he has applied for post-publication scrutiny.
That was done.
There is no change. No, so our regulation says that is binding. We don't have any rules and in the regulations.
What is your rule to show that after it is corrected by one, it goes to the other? Please show that.
Rule 21(6) says in the next matter, that is item number 34. I have
it is annexed. দেখি পরেরটা দেখি একটু পরের ফাইলটা দেখি wait, just wait.
No, your lordship kindly have it.
No, I'll see only the rule. রাখুন এখানটাতে রুলটা আছে. Yes, which portion of the rule you say?
21, regulation 21 has it also got it,
Regulation 21(6), the result of the post-publication scrutiny shall be final and binding. So show me that two teachers check it.
No, that is not written. It is not practice. That is not written in the rules. That is not written. That is not.
Who made the corrections? The same teacher?
No. Different. This is not written in the mention in the rules. Not 8 plus 10 plus examinees are there. And he alleges malafide and malicious people. What is the cause?
No, that I'm not taking into consideration, but show me that it must be written somewhere.
Kindly see method of assessment.
Yes.
Regulation 20.
Right.
The method of assessment of ancestry shall be numerical. That is to say, the assessment shall be made in terms of the marks to be awarded by the examiner. Examination of practice is the other thing. This is the method of examination. The council shall have the grade and classification. It is another thing. We are not related to this.
So I just want to know that why this correction? If I correct one answer script, will I go back and recorrect it?
What played on the mind of the examiner, he is the expert in this matter, in that matter. We can right now we can comment, but from the reasoning your lordship kindly sees, time and again he checked, verified. He was not satisfied the marks he has given. That's why
He gives a marks and he is not satisfied.
No,
You give a mark, somebody else may not be satisfied.
Initially he puts a mark.
But they're not satisfied.
Then after reading the answers,
he gave a mark after reading the answers, not that without reading he gave the mark.
Repeatedly he read the answer.
Repeatedly?
Yes. That's
the,
why
the examiner has so much of time to give repeated look into the answer scripts.
The reasoning is there. Your lordship kindly have a look at it.
I understand. This is what I want to know. Whether the reasoning is of the first teacher or the second one.
But I believe it's a first. Shotik Songa lekha hoyni. And this is page 92. One side reasoning.
If there is a two teachers, the query of the court, then there will be the difference of the ink. Same ink cannot be correct. If the one teacher, same ink. So let there be a production.
Why? You cannot have two pens?
Yes, madam.
Then?
No.
You can have two pens.
No.
When you read for the first time, you use a blue pen. Next, you read for the second time, you use a black one. And the third, you use a green one. Then what happens?
I do not know.
You have so many pens.
I do not know.
Whether each and every correctness what is there in the
I understand, but then with so many scratches and cut throughs.
Reasoning has been given. And Milord, I have relied on two judgments of this honorable court. Milord, in the next matter, I have cited those two judges.
Your learned friend's opening submission is all judgments are against him except one that where he can lay his hands upon.
Judgments of Supreme Court, Milord, says, Milord, in absence of any provision in the relevant rules and regulation, then Milord, a candidate cannot ask for re-evaluation, reassessment of his Milord answer key. And Milord, this is Milord 223 to 2023 life law, Supreme Court 131. Milord, Dr. B.R. Ambedkar University, Agra versus
whoever. Yes.
Lordship, kindly have a look at it, Milord.
Let me see.
Milord, head note, Milord. Re-evaluation of answer sheet. Supreme Court disapproves of High Court ordering re-evaluation of answer sheets when there is no statutory provision. Moreover, the award of marks in descriptive type of answer. This is the descriptive type of answer. Essentially remains a matter of subjective assessment, and the court would not be entering into that arena of assessment which remains reserved. What the examiner, regulator, however, have regardlessly refuses to interfere relief granted by the High Court.
Refuses to interfere with the relief.
But
that means
principle has been laid down, Milord.
Yes, certainly.
One These honorable court after Milord, considering all these judgments, Milord. Milord, after considering all these judgments of the Honorable Supreme Court, Milord, one coordinate bench passed this judgment, Milord, rejecting the claim of the petitioner for reassessment of the answers. All the judgments have been relied upon and all the judgments have been discussed, Milord. All the judgments, each and every judgment, Milord. Right up to Milord, from Milord Maharashtra State Board or Milord Maharashtra was the State Board of Secondary Higher Secondary Education to till Milord. It is judgment pronounced in the Honorable Court. That is, Lords, that also been considered. After the judgment, after it.
23 page, it is with
Direction.
Okay.
No,
Tomato.
one also nature.
Interior type.
After your lordship is looking at the judgment passed by this on a 40th bench of this honorable court. The latest judgment will Dr. NTR University of Health Sciences. That is a paragraph 30. Ultimate paragraph
30?
30.
Yes.
In the matter of Dr. NTR University, has your lordship got it, madam?
Yes.
Your Honorable was placed to observe as under the short question which is posted for consideration before this court is whether in the absence of any provision for evaluation, the High Court was justified in ordering evaluation after calling the record for the answer scripts. In view of the above and for the reasons stated above, the common judgment order passed by the Honorable Single Judge ordering re-evaluation of the answer scripts confirmed by the division bench by the implicit common judgment and order is unsustainable. However, as observed hearing above, as the result of the order is to after re-evaluation or appearing the supplementary exercise have been declared while washing and setting aside the implicit common judgment or orders
Lord, I'm for the respondent contempt, Lord. Lord, in terms of earlier direction, Lord, I filed my complaints, Lord, and in terms of my Lord's order,
Where is the complaint?
Where is the petitioner?
Lord,
Compliance report, we can achieve.
Did you serve the compliance report? Yes, Ms. Shaha. Please unmute yourself.
Unmute with uh,
Yes, please.
Your Lordship, today morning only we have received the opposition, your compliance, Your Lordship. The compliance contains 77 pages, Your Lordship. I have to confront the document with my client, Your Lordship. I'm praying for time for the hearing of the matter, Your Lordship.
Not hearing, you just check up whether the order has been complied or not.
Yes, Your
Then
Lordship. I have
come
to
back.
confront the document.
I
Yes.
also insist, my Lord, because this is with regard to the medical reimbursement, my Lord. They have verified the bills based on which how the mode they have verified. Let the other side will verify, my Lord, and intimate us also if anything calculation part it is done.
All right.
Notice are there, we will pay it, my Lord. That's not an issue, my Lord.
All
As per
right.
Lord's orders.
Please come. Compliance report filed in court is taken on record. Stop. A copy of the same has been served upon the learned advocate representing the petitioner. Stop. The petitioner seeks time to revert with instruction. Stop. On such prayer, release the contempt once again on in the middle of January.
Yes, no problem.
10th of January.
Your Lordship.
2026. Stop. It will be open for the petitioner to intimate the contemners if any discrepancy is found in the calculation provided in the affidavit of compliance.
Yes, in terms of the page number, my Lord, I just indicate now. As page number 74, my Lord.
Yes, last page, last two.
In terms of page 74
Yes,
of
yes.
the affidavit of compliance.
Yes, ma'am.
All right then.
Oblige, my Lord.
Oblige, Your Lordship. Hmm?
Not there.
Good, yeah.
For the petition.
I'm for the question number one. On the container one.
Order complied?
Not yet, ma'am.
Not.
Order is of my lord 1st October 2024.
Not been complied?
Yes, Lordship, it has already been complied with. I have
Why is the
supplied,
petitioner saying no?
and moreover, the contemner has already resigned from the post of chairman, and
So
another new incumbent has already joined.
No,
Last-
my lord, he is still the councillor ward number 1. And my lord directed the board of councillors to consider the representation.
Board of council, not
All right. Where is the compliance? Let me see. Affidavit of compliance?
No, Lordship, yesterday they served the copy upon it. Yes. 28/11.
So today is 4th of December.
Then Lordship kindly give 2 days time so that I can show that compliance has been made.
What is your instruction about compliance?
Regarding compliance, my client instructed that during his tenure, compliance has been made.
What is the compliance? Only making submission will not do. Show the compliance. Has any hearing been given?
No notice has been served, madam.
No notice also has. What type of compliance without a notice? I'll direct your client to remain personally present in that case. The entire board is over here. Just imagine what's going to happen. What is your submission?
Then we give 2-3 days time so that I can take instruction in the meantime.
Under which ward does your construction, unauthorized construction fall? 2.
Ward number 2.
Who is the chairman now?
Now Utpal Bhaduri. Three.
What number? 13.
30.
Please come. Learned advocate representing the petitioner submits upon instruction that the order of the court has not been complied with till date. Stop. It has been submitted that no notice whatsoever was served for compliance of the order, which was passed way back on 1st October 2024. Stop. Learned advocate representing the contemners.
No, not all contemners. Only Apun Shah.
One.
Only one.
What about the others?
Others I don't have.
You do not have any instruction? You served upon all?
Yes, ma'am. This affidavit service in the record, ma'am. Ma'am, the last occasion, ma'am, directed to serve Mr. Devashish Mukherjee.
Yes, because he represented. Who represents the municipality now?
Now represented Mr. Pritam Das, learned advocate representing the municipality. After Mr. Utpal Bhaduri being appointed as a chairman, Mr.
I saw your name. That is the reason I directed the service of copy upon you.
When Mr. Shopun Shah was the chairman, I was representing the entire Mal municipality.
কি বললাম? Learned advocate representing the contemner number 1, comma, the erstwhile chairman of the Mal municipality submits that the order of the court has been complied with. Stop. There is, however, nothing on record to suggest compliance of the said order. Stop. It has been brought to the notice of the court that currently Mal municipality is represented by Mr. Pritam Das, learned advocate. Stop. Let since the contemners were served and none entered appearance, accordingly, let a notice be served upon Mr. Pritam Das, learned advocate, intimating that the matter will appear in the list on 22nd January 2025. 26. Stop. An affidavit of compliance by the contemner number 1 and the other members of the Board of Councillors of Mal municipality shall be placed before the court on the adjourned date with a prior copy upon the learned advocate representing the petitioner.
Deeply.
Keep this notice on record. Keep this notice on record.
To your lordship, and for the my lord, the petitioner, the violations of your lordship's order in the earlier occasion, my lord.
Yes, Lordship.
I have served to the
Lordship, I on behalf of the LS Contemner 1, Lordship, I have just now the affirmation of the compliance report affidavit, Lordship. I could not serve the petitioner, Lordship.
My lord, I served to the contemner directly. My lord, thereafter they did not appear. So your lordship, please to direct me to serve the advocates for this writ petition. Served, my lord. This is the affidavit
Lordship,
of service.
already the order is already complied with, Lordship.
Are you aware of compliance? No.
Nothing is there.
Lordship,
my lord.
already
Formal submission. My lord, I have served on 24th of November of this November, lordship. And service. My lord, if it has been complied as per his submissions, my lord, let them file a compliance report, my lord, in the form of
He has
affidavit.
prepared, he says he has prepared it.
But in the form of affidavit.
Yes, yes, certainly.
already affirmation today I affirm it, Lordship.
Today you affirmed.
But I
Please
could not
pass on a copy to your learned friend.
send the yes, Lordship.
You could have sent it through
Lordship.
the soft copy. You could have sent. Please come. Learned advocate for the petitioner asserts that the order of the court has not been complied with till date. Stop. Learned advocate representing the contemners submits that
Only contemner
the
number one, Lordship.
There are two contemner respondents, lordship.
ADM.
Yes, Lordship.
Who will be the appropriate authority? The ADM.
Directions upon both the contemners, lordship. If your lordships kindly see
Who-
your lordship's order.
Who appears on behalf of the Darjeeling Improvement Fund?
But if you read lordship, the state
Lordship
said that
is state, Lordship, then contemners, Lordship.
Yes.
From the order of the writ petition.
Right. In that case, you will represent both.
Lordship, Lordship. Lordship.
কি বললাম? Contemners submits that the affidavit of compliance has already been prepared and affirmed, but the same could not be served upon the learned advocate for the petitioner. Stuff. It has been submitted that a petitioner stuff. Let the affidavit of compliance be served upon the learned advocate for the contemner immediately. Stuff. Release the matter for further consideration on 22nd January 2026. Stuff. It will be open for the petitioner to file exception to the affidavit of compliance, if so advised. Affidavit of service is taken on record.
Lordship, kindly grant me liberty to file the compliance report before the circuit bench department.
All right. The
Lordship.
affidavit of compliance be filed before the circuit bench at Jalpaiguri.
Grateful, Lordship.
Copy will be given to you.
Lordship, immediately. Today.
3. Dismissed. None appears on repeated occasions.
Item number 4.
Let me see.
Item number 4.
Let me see the file once. Same order. Dismissed. None appears on repeated occasions.
Application item number 170.
Till date, my lord, they have not compared your lordship's order, last order, whereby, my lord, your lordship directed them. My lord, your lordship kindly see your lordship's last order.
Where is the Howrah Municipal Corporation?
What is appearing?
Why?
I don't know, my lord. And your lord, against your lordship order, they preferred an appeal on the last occasion. I submitted before your lordship. And the division bench, my lord, observation is, I have handed over before your lordship kindly see.
What the division bench has observed?
My lord,
HMC will carry out the such and such.
my lord, may I read the division bench?
No, I have read
Yes,
it.
yes. I have.
Please see if Mr. Banerjee is there outside. I'm passing it over. Call him. Next.
And till date, my lord, they have not demolished
Oh,
after.
call him.
171.
Item number 171 on appear for the alleged contemner.
But your lordships, on the last occasion, I directed for filing of an affidavit of compliance. But I have the compliance with me, my lord. I was praying before your lordships for some time for filing the affidavit. My lord, your lordship's order was, my lord, to take a decision with regard to the unauthorized construction. The Panchayat authorities, but I am the Pradhan of the Panchayat.
Yes.
But I have taken, we have taken the note of everything. They were served, all were present, and it was found that there was an unauthorized construction. We have taken the records to the subdivisional officer under section 23(5). I have the records with me. We suggest that, my lord. My lord, I was
Suggest that.
we have, my lord, forwarded the records of this case to the subdivisional officer who is to
Show
take
me.
the final call, my lord. My lord. It is a belated act, my lord. I admit, but it has been done pursuant to your.
Are you aware? Hearing?
Hearing was done.
Yes,
We
they
have
were
taken
present.
decision that decision was communicated to me. But so far, recommendation before the
Recommendation.
But we have the report also. It is that my lord, I need to have it found.
23 order.
Yes.
And you are complying in 25.
My lord, this is the belated action, my lord.
All right. How much cost is to be deposited?
My lord, I
10,000?
I cannot say, but only I can say this, my lord, that the order probably is being compliant with. We shall take all endeavors to have it
Yes,
done.
please do and pay rupees 10,000.
Lord, I leave it up to you, Lord.
Yes.
The order is this, my lord. It has been found that both the petitioner as well as the private respondent is, my lord, has made.
Take steps, sir. Why are you sleeping?
But it is.
2 years.
I understand that, my lord.
Aligunta? Learned advocate representing the contemner submits.
Appointed to see, my lord. What is the problem? We will be there also.
How many floors unauthorized was there?
That's one. My lord, E plus one is
sanctioned.
Construction
First
is made
E
up.
plus two, the entire second floor is unauthorized.
Second floor has been demolished.
Have been demolished.
Only the roof. Your lordship direction.
Walls?
Special officer we said. I have heard that everything.
Your lordship specific direction was that to demolish the outer wall also. Your lordship kindly see, my lord, this is the picture. Yesterday, my lord, it has been taken. This is the picture, my lord. 3rd December picture. No demolition of the outer wall. Your lordship directed that to demolish. Otherwise, my lord, your lordship kindly see beams are also there. No demolition of the outer wall.
Outer walls are still.
Now let the engineer comes and says they are enmity between two. They are want the entire building.
No. See, if the second floor is completely
Yes.
unauthorized, why don't you demolish the second floor?
And why not let it be taken up next week? I will bring the engineer and I will say that what is being doing.
And the division bench also confirm your lordship's order. Kindly see, my lord.
It's all right. But the wall still remains.
I'm asking them to then come, my lord.
See, the pictures have been taken in such a manner so that you do not understand how the construction is there.
Then let the special officer goes at least.
Who has taken this picture?
The engineer itself.
Engineer himself.
An engineer can come also.
This is the yesterday picture, my lord. Kindly
They
see.
say that is yesterday's picture. I don't know. If your lordship calls the engineer, I will call him. Or my lord, take it upon next week. I will come with the second floor.
Engineer
What is the picture of the second floor?
HMC has forwarded a report signed on 2nd December 2025.
Boro 2.
Achha, Boro 2. Bollam na? Which mentions that
And 3-4 buildings are completely touching the other this building. If anything done, that will cause serious damage to the damage means fatal accident may also happen. A special officer may be appointed, my lord. Actually, I also gone there because I am very much scared about your lordship. That anytime your lordship will call the engineers and everyone.
আচ্ছা কি বললাম হুম 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 which mentions that the having their outer wall as well as the foundation or that the outer wall as well as the foundation are in common with the adjoining building.
In four sides, all the buildings.
My lord, this is the last report.
This is the list.
And my lord, prior to that, my lord,
Further demolition may cause serious damage to those buildings.
And it is an old building, madam. Madam sees that it's an old building.
yeah, my lord,
Stop. The
আপনি থাকুন না, ভেঙে দিন।
এই newly
the
constructed
building has a sanction plan up to the first floor level, but the construction has deviated from the sanction plan. An unauthorized construction of the second floor has already been demolished. There is no front, rear and side space left. So, the portions which have been deviated
যখন বলছেন ভেঙেছেন
is very
কালকে তোলা
difficult to demolish.
বলে যান কোর্টকে মিসলেট করেন
Special officer বললাম।
আপনি তো মিসলেট করছেন
আপনার
এই
Paragraph.
কালকে
The petitioner as well as the Howrah Municipal Corporation has placed photographs in support of the submission that the unauthorized floor has been completely demolished. No, has been demolished. Stop. From the photograph produced by the petitioner, it appears that though the roof of the second floor has been demolished, but the walls still remain. Stop. The assistant engineer borrowed to Howrah Municipal Corporation is directed to remain virtually present
He will be physically
on
no problem.
on 8th January 2026.
He will be physically present.
Stop. The corporation shall proceed to demolish the outer walls as far as practicable prior to the adjourned date and file
What happens, madam?
and
Just placing this.
file a
adjourned
further
for touching with the
report
buildings.
before the court. You say touching. Look at this picture.
Let me see.
Show it to him.
yes my lord
Where it is touching.
and my lord
It is not touching.
what he is submitting I failed to understand. He said that this is old building new construction my lord
I will come.
now he said
It is not.
and
Let a copy
and-
be given to me.
and my lord more one thing more
Copy be given to me. I will show.
my lord
Show
yes,
the
yes,
picture
yes,
so that
I
he
will-
can show
I
it
will
to
hand
his
over
client.
just now my lord
hand over আমাকে করুন না, আমরা তো
আরে দিচ্ছি and my lord one thing I have to submit my lord your lordship direction was entire unauthorized construction so far the top floor is concerned and the deviated portion of the ground floor and the first floor now my lord kindly see no demolition of the deviated portion result is my lord my
I remind me on the next day. I'll speak to the engineer.
Madam.
deeply of this man
Let him
deeply of
make his submission.
deeply of and my lord I am handing over a copy
Yes.
Yes, I will give them a copy immediately. Well, virtually or physically also he can be present, madam.
I have no problem. He appears
I will
virtually.
call him physically. Let them come.
I'll deal with him appropriately. Next.
deviated portion my lord untouched
172, my lord, I will speak for the petitioner, my lord. My lord, kindly see the last order, my lord, as by your lordship, paragraph 4, my lord.
Yes.
Direct the municipality, take the.
Chairman of the Garulia municipality.
I appear for the municipality, and after the order was passed, another further payment of rupees
1,20,000.
1,22,800.
Payment you are made, there is no dispute.
Yes.
Speak, my lord.
I
disputed, my lord, that PPO, my lord, last occasion, my lord,
it,
it was handed over to your lordship, my lord.
Yes.
That PPO was wrongly with effect from date of joining, my lord.
Right.
Lordship,
What is this point?
Lordship, I
It
have
should have been from which date?
Lordship, or I have received it on phone. Lordship, that's why. They were. She was appointed in 1/1/1986 and was as a casual employee till 28/2/2006. So the calculation starts from 2006 when the service was regularized and as a permanent.
Why will he not get the benefit of the prior service?
Was on a casual. Her appointment was on
What was the
as
direction of
casual.
the court?
Page 23 of the writ petition, my lord, can it undo?
No, how was it disposed of?
My lord, page 23 of the writ petition, my lord. First paragraph, last line, my lord. The effect from the date of joining such post, my lord. That is letter of approval, my lord.
Page 23
of writ petition.
with effect from the date of joining.
Yes, first paragraph, last line.
Yes.
And that approval was issued, my lord. 53 employee, my lord. Total 60 number of employee, casual employee was forward.
Listen, I think you are required to file a fresh writ petition because you have to challenge it by way of a fresh writ petition. Is there any mandatory order of the court that you have to be regularized or paragraph 6 will not do. The court's order is
Page 25.
to direct the authority to compute the terminal benefits, including pension.
Yes.
Lordship,
So there
can
is
I?
no order that the past service has to be taken into consideration.
Stated all these things in my writ petition. They did not raise any dispute at the time of hearing, my lord. Municipality appeared.
I understand.
Not only that, my lord. Kindly see my representation. Page last page, my lord, page 28.
Please come. The petitioner seeks terminal benefits. Stop. It appears that the service of the employee was regularized from 1st March 2006 and PPO has been issued from the said date. Stop. According to the petitioner, the employee joined service in the year 1986.
1/1/86.
1st January 1986.
As casual employee.
Accordingly, he ought to be provided benefit on and from the said date and not from the date of regularization. Stop. Next. The
Lordship?
is of the opinion that the issue as to whether the PPO has been issued from the proper date or not cannot be looked into or adjudicated in the contempt application. Stuff. In view of the above, the contempt application stands disposed of. It will be open for the petitioner to challenge the action of the respondent authority in issuing the granting the terminal benefit from a later date. Contempt disposed.
Grateful, Lords.
Item number 173.
Yes.
I appear on behalf of the alleged contempt.
Yes.
I appear on behalf of Ms. Malvika Rai for the petition.
Has not been.
Complied.
Has been.
I have that instruction. I have.
Has been complied. Disposed. Complied. Yes.
Item number 174.
As per your lordship direction, I have served the copy of the contempt application upon the alleged contempt. Now kindly see, my lord, page 15 of my contempt application, your lordship's order.
Who is the contemptor?
Video.
Video. None appears on behalf of the contemptor despite service. Step. Contempt rule. Returnable on 29th January 26.
Only rule to be served by special messenger course to be deposited.
Yes. Next.
Item number 170.
Five. Well, in this matter, I am for the petition. As per your lordship's earlier direction, my lord, I have served the copies. This is my affidavit of service. They have received. My lord, before going to the records, my lord, your lordship can just bear me.
Order has not been complied. Not complied.
Nothing. Yes, only they are taking step. Your lordship, our allegation was twofold. Unauthorized construction, unauthorized encroachment. Your lordship directed two authorities to investigate and to take step for removal and demolition. Now only the letter is being issued that investigation will be made. Investigation will be.
But nothing is happening.
Nothing is happening. This is I have annexed all.
Give a copy to him.
Copy
This is February 25.
Yes.
And kindly see page 3, my lord, last portion, order.
There is no other encroachment.
Has this been communicated to the petitioner?
No, nothing, no notice, nothing of the sort.
Make an order and you keep it in your records without communicating. How will the petitioner get to know?
No notice, nothing of the sort.
No notice was issued.
No.
It records that the petitioner made representation and there is a direction for service of notice. Both parties put up hajira. You say no notice was issued. Please come. The petitioner complains of violation of the order passed by the court.
Let them file affidavit, my lord. Let them deposit by filing affidavit.
Learned advocate representing the. Who are you representing? SDO?
SDO.
The subdivisional officer, Bushirat, North 24 Parganas, relies upon the order sheet dated 17th February 2025 to 28th February 2025, wherefrom it appears that the order of the court was duly considered and the same stood disposed of. Stop. There is nothing on record to suggest that the order was communicated to the petitioner. Stop. Next. A copy of the said order has, however, been handed over to the learned advocate representing the petitioner in court today. Stop. The petitioner appears to be aggrieved by the order that has been passed. Stop. Paragraph. The court is of the opinion that the correctness and validity of the order cannot be adjudicated in the contempt proceeding. Stop. The instant contempt application stands disposed of with the observation that it will be open for the petitioner to challenge the order passed by the authority before the appropriate forum in accordance with law, if so advised.
Without disposing law. Your lordship passed two, my lord, the order. There is a two limb of the order. One, unauthorized encroachment. It was directed for investigation and to take step by the PWD department. And another, my lord, unauthorized construction, which is to be investigated and to be ordered to be passed by the SDO. These are the two, my lord, the limbs of the order. Now the SDO has come, my lord, appeared before this court by submitting this. With regard to the PWD department, what your lordship directed, your lordship come, your lordship's order.
You come to this order. It mentions that the ordering portion that
Yes.
after going through all relevant evidences, it is concluded that there is no unauthorized encroachment over the government land in front of such and such.
But your lordship, where is the, my lord, the report of the executive engineer?
Yes, that means you are not aggrieved. You are aggrieved and
No,
you are
I
not
have aggrieved.
happy.
No.
It's better you challenge it and get things done. Service taken on record.
Well, your lordship, where is the, my lord, the findings of the, my lord, the executive engineer?
On that ground, get it set aside.
I am for the petition.
Yes, what is it?
Last occasion, your lordship directed me to serve the notice. I have served. This is my affidavit service. They have received.
Who is your other side?
The order, my lord, kindly see the order, my lord.
Who is the respondent?
Respondent, my lord, Abhijit Sarkar and Orijit Sarkar.
Pradhan of the Gram Panchayat.
Yes. Late container is, my lord,
Yes. Unauthorized construction. Nothing done.
Nothing.
Rule 29th. Next.
One 177, my lord. I am appearing on behalf of the contender, my lord.
My lord, I am for the petitioner.
Has the order been complied?
My lord, order was twofold order. My lord, kindly see the impugn order.
Not complied.
As because, my lord, recent order has been passed, my lord. That recent order has been challenged by writ petition and by a order of under an appeal under section 218(3) has been preferred, my lord.
Before the civil court?
Before the civil court.
Are you aware?
I am aware.
Yes.
My lord, kindly see the impugn order, my lord. Kindly, please. In my contempt application, my lord, page 19.
Yes.
My lord, kindly see, in compliance of the direction passed by this court, a joint inspection, spot inspection was conducted in the presence of the parties. The report of joint spot inspection has been filed in court. A copy of the same circulated amongst the parties. It appears from the report that the unauthorized construction by encroaching the government land, PWD, has been detected. The Board of Council of Kolkata Municipality has mentioned that the municipal authority is not custodian of the land and as such does not have any right to demolish the unauthorized construction. The report of the municipality mentioned about a civil suit is pending, which is pending such and such. As it appears from the report filed by the official respondent that the government land has been encroached upon the private respondent by making unauthorized construction. Accordingly, the official respondent, that is PWD Road, is directed to take necessary steps to deal with such unauthorized construction in accordance with the law. Well, that part till pending. PWD.
Okay.
PWD.
Who are you? Municipality?
Municipality.
Did you communicate this to
Yes,
Deputy Authority?
yes, my lord. My lord, kindly see page 5. Mr. Kartik Chandra Das, the executive engineer, PWD Roads, Government, West Bengal, and Mithun Raul, the assistant engineer. My lord, I am service upon the that.
Inspection to হয়েছিল
হ্যাঁ PWD কোনো স্টেপ নিচ্ছে না, ভাঙতে যাচ্ছে না, কিছুই করছে না।
Page 5.
মানে in my contempt application.
That is the cost item.
That is the cost item. One is the chairman.
Respondent number 3.
2 and 3.
Executive engineer and the assistant engineer.
That part was not done.
Please
This order was passed then against the appeal before the writ petition. One after another was
has been submitted by the learned advocate for the petitioner that the direction passed upon the Public Works Department has not been complied department in the order dated 2nd January 2024
Yes.
has not been complied with till date. The PWD within bracket roads. Stop. The matter relates to removal of unauthorized construction which has been made by encroaching upon the government land. Stop. Next. The let notice be served upon the non-appearing contemners, intimating that the matter will appear in the list on 29th January. An affidavit of compliance shall be filed by the contemner numbers 2 and 3. Let this order be communicated to the aforesaid contemners forthwith. Stop. As regards the contemner number 1, comma, the petitioner does not have any allegation.
Allegation, but he's not demolishing. He's not till date, he's not demolishing without.
Then you say, he says that he has taken.
Only, no, on his part, private land, it is unauthorized without sanction plan.
On his part, there is an order of the civil court.
What order was passed? This is unauthorized construction. Demolition within
Then the
15
civil
days.
court is there.
Civil court. That order be challenged.
Yes.
Without stay.
So what? As regards the contemner number 1, comma, no further order is passed as it has been brought to the notice of the court that the order of demolition which was passed has been challenged by the aggrieved party before the competent forum, and the same and the appeal is pending consideration. Yes.
And my lord, next date fixed on 15 December 2025.
Next.
Number 178.
According to it is appearing for the petitioner lordship. He didn't came today due to severe illness. Lordship praying for not to.
Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Release on 15th of January 2026.
A4 কত আছে 179 I'm for the petition. There is a willful violation of your lordship order dated your lordship 28th of February 2024 appearing your lordship page number 28. So allegation is your lordship that the unauthorized construction that was being carried out by the private respondent lordship was pleased to pass a direction upon the respondent the state respondent the municipality to consider the representation by the petitioner within a period of your lordship 3 months from the date of the order.
Who is appearing for the municipality? Which municipality? Modhamgram.
Yes, lordship.
Show me the service of the order upon the municipality.
Yes, your lordship. Kindly come to the page number 22, your lordship. 22 is the your lordship communication the order. And after that, your lordship, municipality asked me to appear. They have conducted your lordship hearing. I went there, your lordship. I submitted the documents as per the requirements. Despite your lordship, they have not culminated their proceeding.
It has started but not concluded.
Yes, your lordship. The notice is your lordship, appearing in page number 33.
23.
33 and 34.
23. Please come. The order of the court dated 22nd February 2024 has not been complied with till date. Stop. None represents the Modhamgram municipality despite service. Stop. Affidavit of service is already on record. Where is your affidavit of service?
Since I have not served the copy to be.
Huh? There no order of service. Unappears বলছেন তো। হ্যাঁ, এটাই তো first time তো order নেই তো। Let a copy of the contempt. এটা তো non appears. Let a copy. Copy be served. First day order করে দিন। ওটাকে করে দিন আপনি 29th of January. Serve.
Your Lordship, order dated 28, not 22nd.
কি বললাম? All right, serve.
Yes, sir.
I am for the petitioner lordship. I am not in I am not in contact with the client at present,
They
lordship.
will not be in contact with you. Already demolition has been done.
Lordship may be pleased to direct the matter out of the list with liberty to mention.
Material instruction not. Maybe for further. But we have contact.
Acha, learned advocate for the petitioner submits that her client is not contacting with her.
But 1.5 months the demolition has been done.
Stop. Learned advocate representing the contemner relies upon the instruction forwarded by the Assistant Engineer in Charge, Building Department, Howrah Municipal Corporation, signed on 25th June 2025, mentioning that the that most of the unauthorized portion of the unauthorized portion has been demolished. Stop. Next. As it appears that the petitioner is not taking steps to proceed with the contempt application, accordingly, the contempt application stands disposed of. The report be retained with the records.
181, my application, my lord, I have served upon the alleged contender, my lord, filed affidavit of service. My lord, order dated, my lord, 8th September 2024, that will appear at page 9, Annex P. That has not been complied with. Simply communicating a letter, my lord, by the alleged contender, will page 15. Your lordship will see. No steps taken, no followed up action.
You go before the civil court and get it done.
My lord, because the tamarind tree is damaging my house building there, my lord.
Yes.
And that's why your lordship was pleased to direct the authority concerned, the concerned Pradhan. My lord, page 19.
Pradhan will not be able to do anything.
My lord, she is to inquire into the field, my lord, and to take steps on the basis of that. Your lordship's order, my lord, page 9.
I can see.
Followed up action has not been taken. Only trimming of branches of the tree. Nothing else. I am not, in respect of my lord, cutting down the trees, my lord, there. My roof is totally damaged. And the earlier order was passed by this court also, my lord. To that aspect, my lord, I have made all aspect, my lord. Delivered.
And then Anna appears on behalf of the contender. Affidavit of service filed in court is taken on record. Contempt rule, 29th of January. Next. 182. Dismiss for default. Dismissed. Has the order been complied? 183?
Lordship, 183, I am for the respondent, but the copy has not been served. That is the reason I am not appearing.
Dismissed. না, নাম দিতে হবে না।
Lord 184, my lord, I beg to appear for the applicant in this matter. My lord, your lordship's order dated 4th July 2023. Now, my lord, your lordship had passed an order on 3rd of July 2025 directing, my lord, the authorities to file an affidavit of compliance. My lord. A hearing has been granted, but no order has been communicated as yet.
Yes.
Mr. Nayak was appearing in this matter.
Use the microphone so that he can hear.
I'm on behalf of the corporation. My hearing has done. Order has been distributed among the parties. My lord, the demotion process is being conducted.
Let me see your instruction. Lee. Learned advocate representing the petitioner submits that though hearing was conducted by the special officer building, but no order has been communicated to the petitioner. Stop. Learned advocate representing the contemner relies upon the report forwarded by the engineers of the corporation. Building Department, Borough XV
15.
signed on 15th July 2025, mentioning that the special officer building has passed an order of demolition of the entire structure at V-134, SA Farooqi Road, Ward number 138, under section 400 within bracket 1 of the KMC Act 1980. Stop. The order of demolition has been served upon the person responsible for compliance. Stop. It appears from the report forwarded by the engineers that an order of demolition has already been passed. Stop. Let a copy of the order of demolition be served upon the learned advocate representing the petitioner for perusal and for taking further necessary action. Stop. Contempt application stands disposed of. You give a copy to your learned friend. And the order of demolition also, please let it be served.
But,
All right. The Xerox copy of the order, my lord. I will make it from the department.
Once
follow the you can forward this copy also through WhatsApp or something and let the order of demolition be served. Have you followed? And put in your name and not anybody on top of you. Appearance. Only your name. What is your name?
Devangana Dev.
Yes, keep her name over there.
Yes. One submission, the premises number is V134/4. It has been clarified by your lordship's earlier order dated 11th of July 2023. But your
I do
lordship
not
has,
know. The report does not say by 4.
but Lord, the premises number was V134/4. I'm not sure whether it is the same building in respect of which the demolition order has been passed.
This the court also doesn't know. You have to inquire and find it out. Let this copy be served upon you, and thereafter, further steps you can take.
In order also,
But may I make one submission? Lord? Your lordship is disposing of the contempt application. Will it be your lordship's pleasure to keep it pending for at least till the next date? Get a copy, ascertain, and come back to your lordship.
No.
Give me the file once.
Well, item number.
Your matter has been dismissed. I am not restoring it.
Courtroom number 29 where the lifts were. Well, I took the stairs and came back.
What about the young ones who are there with you? Could have sent somebody over here.
Yes,
আচ্ছা এখানটা আসুন এক মিনিট কোনটা ডিসপোজালটা কাটুন learned advocate for the petitioner submits that complaint of unauthorized construction was made in respect of premises number V hyphen 134 by
4.
4.
Yes, sir.
Yes,
Lordship will find that at page 59 of the petition.
S.A. Faruqi Road. ঠিক আছে? The report that has been forwarded. Are you sure? Because I can see from one of your representations, it's V134 mentioned.
Yes, but there was a confusion with regard to the premises number and it was clarified in the order. I have mentioned this and your Lordship had clarified by order dated 11th of July 2023.
Please check up. All right. I'm keeping it pending.
Direction to the petitioner to clarify the premises by the department.
You come up with something new to show that 134 by 4 has been taken care of. All right. S.A. Faruqi Road. Stop. The contemner is directed to forward a further report disclosing as to whether steps have been taken in respect of premises number V-134 by 4. In that case, released on 29th of January.
Item number, humbly praying, item number 183, kindly,
183, you didn't serve copy.
Yes,
Your
yes.
learned friend
Yes,
was
yes.
there.
Yes. Affidavit of service is there.
Just now your learned friend was there.
Mr. Mukherjee?
No, he did not receive a copy.
I have released my affidavit of service, madam.
I'll make it not today. Let it appear in the next day. Let us see what can be done. 183 dismissed হবে না, not today.
Grateful, madam. Grateful, madam.
185.
Lordships, kindly come to the Lordship's order. That is page 23.
Yes. Not complied.
Not complied.
Who is the contemner?
Lordship, the alleged contemner is the Pradhan of the that is Chhata Gram Panchayat, PS Kalitala, Asuti, District 24 Pargana South.
Rule 29th January 2026.
Your Lordship, we are for the petitioners. Lordship, order was passed on 12th March 2024. Page number 26, my Lordship.
Madam, can it be taken up next week? I will come with the records. I think representation considered and hearing has been given.
Sir, your Lordship, already 1 year has been lapsed. Nothing has been done on the part of the... Nothing has been done.
All right. Learned advocate for the petitioner submits that the order of the court has not been complied with. Stop. The contemners are directed to file an affidavit of compliance disclosing the manner in which the order of the court has been complied. Stop. Released on 29th of January.
Lordship, one CAN application is there along with this.
For what?
Name of the contemners has been changed, so we have filed for amendment of the cost item. Notice has already been served, my lord.
No, this will not do. These contemners also change. These contemners also change.
There are two contemners.
Take down the name.
Yes, I'm giving the names. Let them come.
Acha. Leave is granted to the advocate on record of the petitioner
to correct, my lord.
To implead the present incumbent as contemner respondent in the contempt application and serve copy of the contempt application upon the present incumbents. ঠিক আছে? Service is taken on record.
Commissioner.
Do one thing. You take out the copy of the contempt from here and hand it over to Mr. Banerjee. Do you have a copy?
I have a
You have?
amendment.
Not the amendment, the contempt.
Yes, yes,
You have it?
I have.
Tale, you can take it back. Please
I
stop.
think no need of giving them new, I can know that. If I give it to your lordship, as it is 29, they can give.
Yes. Only to keep all the records proper,
Right.
this order is passed. You appear.
And I will come with the complaints.
Acha. The affidavit of compliance filed in court is taken on record. Stop.
No, affidavit of complaint is not
The-
filed by you today.
No, affidavit of service. Service is taken on record. Stop. The unserved envelope along with the copy of the contempt is filed in court. Stop. The unserved envelope is retained, but the unserved copy of the contempt is returned to the learned advocate for the petitioner. You take the copy back, the envelope will remain.
My lordship.
Followed?
My lordship.
এটাকে কেটে ওটা কাগজটা খামটা রেখে দেবেন।
Much obliged, ma'am.
সজনরাই থাকুক। এটাই থাক।
আচ্ছা ক্যানটা ডিসপোজ হবে। Can shall be disposed.
Applicant, my lord.
ক্যানটা আছে পেয়েছেন? আনতে দিন ক্যান
90% of your lordship.
এটাতে 193 2 নম্বরটা কিসের? Are you aware as to what the other can is of? Can 2.
I have got one can. That is number one. Only one.
That is for amendment.
That is one.
What is the other can for? Are you aware?
Oh, my lordship. Can
But I can see 2 cans in the list.
এবার দেখে নিন।
It has to be checked. আমাদের CIS এ বোঝা যাবে না কিসের ক্যান?
amendment of cost title, can 1 and can 2.
দুটো পার্টি আছে, দুটো ক্যান আছে। Both disposed.
29 January. No, only one thing, item number 193, if I am not here, he is there. See, my only password is civil plate. Here is the content, I am scared any rule may be issued.
Yes.
I beg to appear for the petitioner applicant. Pursuant to your lordship's direction, I have served the contemner. In the meantime, my lord, one meeting was held, and the my lord, contemner has found that the unauthorized construction is there. My lord, without sanction plan, the construction is there. My lord, it
Let's
is
take steps for demolition
Yes.
separately.
my lord, through SDO, my lord, I have
Did you forward it to the
yes,
SDO?
yes, yes. Yes,
Copy as
Show.
দেখেন
Please show.
SDO কে forward করতে বলেছেন কপিটা দিয়েছেন
Learned advocate appearing for the petitioner submits.
It is my instruction that it was forwarded, but that copy is not with me. Copy of the order is there. Both parties have been
Let me see.
served.
Acha. Learned advocate for the petitioner and the contemner submits upon instruction that the steps have been taken for complying the order passed by the court and unauthorized construction being detected, records of the case has been forwarded to the subdivisional officer for passing a final order in the matter. There is nothing to show that it has been forwarded.
Yes, yes, that copy is not till now, my lord.
Please forward because I'm recording your submission that it has been forwarded. Are you sure whether it has been forwarded?
I am
Then later লিখবেন না, both will fall in trouble. Now লিখুন যে and unauthorized construction has been detected. ঠিক আছে, stop. The
some direction.
Pradhan is directed to take necessary steps to forward all file to the subdivisional officer for taking further necessary steps in the matter in accordance with law. Contempt disposed. Service is taken on record. The reasoned order dated 9th September 2025, signed by the Pradhan of the Gram Panchayat, be written with the records. Next.
Very good service. My lord, yeah, the video without acquisition started construction over my land.
Video started construction.
That's why your lordship.
For the alleged contempt.
That's why Honorable Court directed the video to take appropriate steps after field inspection.
Yes.
The order at page 23.
Yes.
Yeah. After serving notice, they did not start after finding contempt. They started measurement the land. At page 230, during pages of the my surveyor and the BLRO, it was detected that more than 3 decimal land have been acquired, enclosed. Thereafter, the demarcation of land stopped. At the end of they submitted the submitted report. The report has been complied without demarcating my land. This is the position.
The order was not for demarcation. The order was to see whether any unauthorized construction has been made.
My over my land they have constructed. Your lordship passed order.
Over your land, go before the civil court and get it done. Who are you for?
My lord, I am for the alleged contempt. My lord.
Who is the contemnor?
My lord, the video.
Let me see what you've done.
My lord. My lord. My lord, currently comes to the last paragraph, my lord. My lord, the petitioner's allegation is that the construction has been constructed.
Did you communicate this to the petitioner?
I do not think so, my lord. I have no information, my lord. To be candid, I have no information.
Passed order in March 25 without communicating. He can challenge this. He could have challenged it. Please come. Learned advocate for the petitioner submits that the order of the court has not been complied with. Learned advocate representing the contemnor / BDO, Khejuri 2 development block, relies upon the order sheets of the block development officer. Dated 27th March 24, 13th June 2024, 28th January 2025, and 5th March 2025. So, it appears therefrom that a spot inspection was conducted and it was found that the drain has been constructed over plot number 311 within bracket LR under Mauja Hadirpur within bracket JL-64 bracket close, which is vested to the state. Stop. The claim of the petitioner that the construction has been made over his private plot of land has been found to be improper. Stop. The representation filed by the petitioner stood rejected. Stop. From the documents handed over by the learned advocate representing the
at page 30, there is a clear encroachment.
BDO. There is no proof of service of the order dated 5th March 2025 upon the petitioner. Stop. Let a copy of this order be handed over to the learned advocate appearing for the petitioner. Stop. Let a formal order be communicated to the petitioner by the BDO. Stop. The contempt application stands disposed of. It will be open for the petitioner to challenge the order of the BDO before the appropriate forum in accordance with law, if so advised. Do you have a copy?
Yes, my lord, I have.
Only the order sheet. Others are not required to be given. But the order sheets, please give a copy so that he can take necessary steps. Disposed.
My lord, I am for the petition. My lord, copy served, my lord. 20th February, your lordships, my lord, 20th February 2024, page 19. My lord, illegal construction, my lord, your lordships.
Nothing done? All right, rule issued. 29th of January, it is returnable. Service is taken on record. Next.
I am for the petitioner, my lord. I am for the alleged content, my lord. My lord, service, my lord. My lord, according to the, my lord, a report was handed over after filing the contempt application, my lord, wherein, my lord, they have taken a point, my lord, that since the construction is in question, my lord, is under Awas Yojana, so sanction plan is not required for, and as such, one can, my lord, construct
whatever he feels
whatever
like.
they can like.
The allegation is encroachment.
My lord, encroachment, my lord, there is, my lord, family settlement, my lord. In the said family settlement, some portion is required to be kept vacant, my lord. Without keeping such vacant portion, my lord, they have constructed without following any norms and procedure of the panchayat, my lord.
Has this order been communicated?
Yes, yes.
3rd September 2024 order communicated to you?
3rd September. Date is not here, my lord.
Please come.
I am giving further copy.
Give a copy. The allegation of unauthorized construction made by the petitioner was considered by the Gram Panchayat.
Not considered, my lord.
And it was found that the subject construction was made under PMAY within bracket G scheme, where there is no requirement of obtaining prior sanction plan. Sanction plan. Stop. It further appears from the report of the Pradhan signed on 3rd September 2024 that the beneficiary received the installment of rupees 60,000 but did not construct the house. The beneficiary also defaulted even after taking the money, thereby causing misuse of the government scheme. Stop.
This is not the part of the order and part of the matter.
Right.
Yeah.
Next, the as the Panchayat has come to a definite finding that there was no requirement of taking sanction for raising the subject construction. Accordingly, the court is not inclined to proceed with the contempt application any further. Stop. Let a copy of the order of the Gram Panchayat dated 3rd September 2024 be served upon the learned advocate, served upon the petitioner, with an additional copy to the learned advocate to challenge the same in accordance with law. Already served. Upon the advocate টা লিখতে হবে না, petitionerটাই শুধু লিখবেন। ঠিক আছে? To challenge the same in accordance with law, if so advised. Stop. Contempt disposed. Service is taken on record.
Your Lordship, I am for the petitioner. Your Lordship, I pray unconditional apology because Your Lordship, in the contempt application, one document has been mistakenly annexed. I want to file one supplementary affidavit to rectify that defect, Your Lordship. Because the representation of the communication, which was required to be annexed in contempt application, it was not annexed, Your Lordship.
I say that no violation of your ladyship's order. Why I say so, Willard? If your ladyship kindly takes your ladyship's order, which is at page 19 of the application, I was not made a party by the order of 10th of January. I was impleaded as a party, and there was a direction upon me to serve a copy of the representation which needs to be considered by me. Now, milady,
who are you?
I am the alleged contender, the Pradhan.
All right.
Now, milady, that representation vis-a-vis any notice has been served upon me.
There is nothing.
Nothing. I can substantiate, milady. Kindly takes up para 5. Your petitioner states that the petitioner hearing duly communicated the solemn order dated so and so and the representation dated so and so to his learned advocate vide letter dated 2nd of February 2024. Now, milady, kindly takes up page 24, the annexure P2. This is a letter of 19th of May 2024, and the track report shows that it has been communicated to all the parties except for me.
Your Lordship, kindly consider one thing, Your Lordship. This document is not relating to this matter, Your Lordship. Kindly consider my supplementary affidavit once.
Give a copy.
Yes, sir.
Supplementary affidavit filed in court. Did you go through the supplementary?
Yes, milady, but here also no track
Nothing.
report is showing
Your
that it has been delivered
track
to
report
me.
was not available at that point of time, but postal
How did
receipt.
you show that the contemner has been served?
Yes, at page 41, Your Lordship, the postal receipt is there, but unfortunately, the track report is not there, Your Lordship.
All right, you comply the order now. Now you got to know it.
Yes, milady. Though, milady, I submit that the BDO has sought for some instruction from me. I have duly communicated and I have inquired, and we found that there is some unauthorized construction.
Yes. So why don't you take steps?
That's it, Your
That
Lordship.
needs to be that needs to be forwarded to the SDO, milady.
Do it.
Very well, milady. We'll do that. Then the contempt application can be discussed.
Right.
I'm grateful,
Give
Your
me
Lordship.
those copies.
Yes, these are on instruction.
Supplementary affidavit filed by the petitioner is taken on record. Copy of the same has been served upon the learned advocate representing the contemner. Stop.
Last line of the first page, milady. Though it is unsigned copy, communicated to me only for the purpose of instruction.
All right. The learned advocate representing the contemner slash pradhan of the Gram Panchayat submits upon instruction that the complaint of the petitioner has been considered and it has been found that considered and unauthorized construction has been detected. Stop. The Panchayat shall take steps to forward all papers to the subdivisional officer. Paragraph. As it appears that the Panchayat has already considered the issue and has detected unauthorized construction, accordingly, the Panchayat is directed to take steps to forward the file of the unauthorized construction to the subdivisional officer for passing a final order in the matter. Stop. The hand over a copy to him also. Or do one thing.
My lord.
Yes.
My instruction is that demolition work started. Considerable portion of the building has been demolished, but thereafter my client did not contacted with me.
All right. Yes.
Most of the unauthorized portion has been demolished. That's my instruction.
Please take down.
My lord has seek for police help. My lord has directed for police help. So we have rendered the same, my lord, state.
Learned advocate representing the petitioner submits that the last information that he received from his client is that the demolition work started, but the petitioner did not make any contact thereafter. Paragraph. Learned advocate representing the contemner slash Howrah Municipal Corporation submits upon instruction that substantial demolition work has been done. Stop. Done in the presence of the police. Next. As the petitioner does not appear to contest the matter any further by not contacting with his learned advocate, accordingly, there is no requirement of proceeding with the contempt application any further. Stop. The contempt stands disposed of.
After complaint number 2, Korea PS. Complaint number 2. The report.
Yes.
The
Please
report
give.
constitutional.
Let me see.
Complaint number 2 report. Next page. Next page, no construction work is going on. Korea PS. Corporation is done.
None appears on behalf of the petitioner at the time of call.
Yes.
The communication made by the officer in charge, Koraya Police Station, signed on 7th November 2025, filed in court is taken on record. The contempt stands dismissed for default.
Mala, I am for the petitioner. Mala. Your Lordship, earlier direction to sub copy of the contempt application upon the refused. Mala, can you see?
Who refused?
Contemptor.
Who is the contemptor? All right, give. The affidavit of service has been filed in court, wherefrom it appears that the contemptor refused, that the contemptor, being the Pradhan of the Gram Panchayat, refused to accept the copy. So, let contempt rule be issued. Returnable 29th January.
And for the petitioner, my lord. Submitting the affidavit of service, my lord. I have served and my lord is clearly online.
Your ladyship, I am appearing for the petitioner, your ladyship. Your ladyship's order, your ladyship's kindly come to page 21, the operative portion of the order, your ladyship. Page 21, para 1, para 2, and para 3. In a matter of unauthorized construction in a panchayat area, your ladyship was pleased to pass this order. Your
Rule 29th, serve.
Grateful to your ladyship.
This is my the lordship's order has not been complied with. We have served the copy, further copy, but no response.
Who is the contemptor?
Lord Oswani Mukhopadhyay, the chairman of the Barasat municipality.
Chairman of the Barasat municipality?
Yes. September 2022 is not completed.
Rule 29th. Service is taken on record.
Lord, this is rule, Mila. Grateful.
Yes, next.
Order is complied with.
All right. Order complied, disposed. Next. 199 to 98 এর সাথেই রয়েছে।
Lordship, I'm for the.
What you are carrying in your hand? Service?
Yes, Lordship, but the thing is, unfortunately, the contemptor has died.
Who is the contemptor?
Last time, the contemptor was Shubhra Kanto Odhikari.
He has expired?
Yes, my lord, he has expired.
Who was he? Pradhan?
Yes, my lord. Pradhan of the Gram Panchayat.
All right, please come. Learned advocate for the petitioner submits that the contemptor has expired. Stuff. Leave is granted to the advocate on record of the petitioner to implead the present incumbent as party respondent and serve copy of the contempt application upon the added respondent. Release the matter for further consideration on 5th February. Grateful Lordship.
I appear for the petitioner. My contempt petition,
Molester is appearing for the municipality. My lord, he is engaged in another court. Can it be made not to them, lords?
Just let me hear.
Presence is required.
His presence is the.
but this is after service. May I file the affidavit of service? The act of contempt is, my lord, breach of an undertaking given to your lordship. My lord, if lordship sees, my lord, the undertaking given, lordship kindly takes, my lord, page 72 of my contempt petition.
Yes.
Yes. Page 72 is the report given by the municipality. My lord, kindly takes page 75, paragraph 9.
Yes.
But the executive officer of South Damdam municipality, who is the contempt number 4, undertakes that necessary steps be taken within a reasonable period for acquisition of the aforesaid area of the land in terms of the West Bengal Municipal Act. Now, my lord, after filing of the report, lordship passed an order, my lord, which is at page 47 on 17th of July, that pendency of the writ petition will not stand in the way of the municipality to take steps in terms of the undertaking given. Now, my lord, nothing has been done after the, despite the undertaking given, because my lord, it is my land.
And the writ petition has been disposed of?
No, writ petition is pending.
Still pending.
It's pending. My lord, my land, they have encroached. They have constructed a reservoir, water reservoir.
All right. Any steps taken?
Lord, so kindly makes it not to them, Lord, next Thursday.
Kindly keeps it tomorrow then, my lord. This is pending for quite some time. My lord, the difficulty is on my land, my lord, there is a water reservoir which has occupied round about, my lord, 30 to 40% of the land. What fell from your lordship was that since it, my lord, provides water to various localities, my lord, it will not be fit to demolish that. However, my lord, the area can be formally acquired by them and I can be given the required compensation. My lord, that exercise is required to be done, which has not been done.
Please come. The petitioner complains of violation of the undertaking given by the municipality before the court. Stuff. The municipality is directed to file a report by way of affidavit disclosing its stand. Such report shall be prepared and circulated by 22nd of December. Released 15th of January. Next.
May it be in the first week of January, subject to your lordship's convenience, my lord.
I'm keeping it on the second week.
Very
For 1 week, you are making submission.
Election, my lord, will start
Whose
again.
election?
They will take time. My lord, kindly see, my lord, since when my lord has given the direction.
17th of July 2020.
You call the next matter, please.
For the petitioner applicant, my affidavit of service, well, it has been served. And I've kindly come to the page number 19 of my contempt application, the operating part. Nothing has been done till date.
Who is the contemptor?
Sahib Nagar Gram Panchayat, Mr. Krishna Mondal, the Pradhan.
Rule 29th of January.
My lord, I am for the petitioner. This is my affidavit of service.
I am for the contemptor, my lord. Jagadishpur Gram Panchayat. My lord's order was that to consider their representation. During consideration, inspection was held, hearing was held, found that both the petitioner and the private respondent do not have possess any sanctioned building plan. We have referred the matter before the subdivisional officer. This is a communication.
You are aware of all this?
Yes, ma'am.
All right, please come. Learned advocate representing the for the contemptor submits upon instruction that the order of the court has been complied with. Stuff. The Gram Panchayat considered the representation of the petitioner and detected unauthorized construction. Stop. The Panchayat has forwarded all papers to the subdivisional officer, Howrah Shodor, by a communicating letter dated 8th April 2025, which was received by the office of the SDO on 9th April 2025. Paragraph. As it appears that the Pradhan has already taken steps in accordance with the direction passed by the court, accordingly, there is no requirement of proceeding with the contempt application any further. Stop. The same stands disposed of. Stop. It will be open for the petitioner to follow up the matter with the SDO. Next. Salvi is taken on record.
SDO, we issued notice, my lord, for hearing, my lord. Dated 4th. It is.
Keep it with you. You follow up with the SDO.
Great.
I am for the petitioner in both the matters. It's my application.
Who is your other side? Who is the contemptor?
Uluberia Municipality.
Uluberia. Yes.
My lord, the order was passed on 20th February 2024, wherein my lord was pleased to pass a direction upon the municipal authorities to serve notice, conduct hearing and make spot inspection. Hearing was called for firstly on 15/3/2024. Thereafter, spot inspection was held on 30th.
Then what happened?
Of April 2024. Thereafter, a meeting was called on 24th May 2024, but no order has been passed. Apart from that, the private respondents have been pressurizing me, assaulting my family to withdraw the case. No order passed, no compliance of the order because the direction was to dispose of within 12 weeks.
Rule. Rule is issued. Please serve. 29th of January, it's returnable.
206, item number.
206, I am appearing on behalf of the contemptor, my lord. Order has already been complied with. Rescind order has been passed, my lord. Compliance report, my lord. Initially, the order is that, my lord, to conduct an spot inspection, and the spot inspection has been done, page 12, my lord. After that, my lord, a rescind order has been passed, my lord. Operating portion, my lord, starts from page 15, my lord, and that rescind order has already been communicated. All the parties are received the rescind order by signing.
Please come
on the application form.
None appears on behalf of the petitioner. Stop. Learned advocate representing the contemptor relies upon the affidavit of compliance filed in court in support of the submission that the order of the court has been complied with. Stop. A recent order has been passed and communicated to the parties. Recent order has been passed on 26th February 2025, and the same has been communicated to the parties. Stop. Next. As the petitioner is not represented and an affidavit of compliance has been filed, accordingly, the contempt application stands disposed of.
Lord, I am for the
petitioner,
contemptor number 3 and 4.
Last occasion, losses were free to direct me to serve the copy of the contentment. I have already served. I'm on the way, my lord.
All right, he's there. Well, has the order been complied?
No, not complied.
My lord, I am for the contemptor number 3 and 4. My lord, state. Lordship is this court is directed, my lord, to acquire the acquisition. But my lord, this plot is for the government land.
Report the thesis.
Lord, may I place report?
Yes, please give.
Is not the private land.
No, my lord, this is my land. I have deed of second page. No, no, no.
My lord, kindly see page 30, my lord.
My lord, Mr. Kolkata is on next one. Well, short process. There are so many in the panel. Then why will the matter be passed over for only one? My lord, everybody is in some court. They are all coming. Let them remain in courts.
Resolution করেন। Change, exchange করে দাও।
Did you communicate this order to the petitioner?
No.
You please shift this side so that she can stand. You shift towards your left.
I shall take instructions on.
Please shift, let her stand. Yes.
Shall take instructions on this point.
What you will take instruction?
Whether it is.
I've got not.
Sir, this is not mentioned in the report.
Please come. The petitioner alleges violation of the order dated 8th December 2023. Stop. From the report that has been forwarded by the Special Secretary to the Department of Urban Development and Municipal Affairs. Department of Urban Development and Municipal Affairs, Government of West Bengal, signed on 10th January 2025. It appears that the authority has come to a conclusion that the subject plot of land is belongs to the government, and so the question of acquisition of the land does not arise. Stop. There is no document to suggest that the order of the department was communicated to the petitioner. Stop. The petitioner asserts that the plot of land is the private land of the petitioners. Stop. Paragraph. As it appears that the authority already considered the prayer of the petitioner and has come to a finding that the state is the owner of the land. Accordingly, the court is not inclined to proceed with the contempt application any
My
further.
lord, kindly hear me for a moment, my lord. Kindly direct to supply the copy. I will file affidavit in respect of the evidence
Stop.
report.
Let
I am to submit my document.
copy of the order of the Special Secretary of the department be formally served upon the petitioner. Stop. It will be open for the petitioner to challenge the same in accordance with law before the competent forum, if so advised. The contempt application stands disposed of.
Great, Petit Lord.
My lord, kindly direct to supply the copy, my lord.
Yes, serve a copy on.
I am, sir. Evidence service.
Service is taken on record.
Much obliged.
Yes, Mr. Jana.
Contempt application, my lord.
Order has been complied.
No, my lord. My lordship's order was there to self-demolish and also my lord kind pleasure to direct for giving undertaking by affidavit. He has filed that But since 2024, nothing has been done, my lord, as yet.
You are the contemner? Ooh, contemner means Pradhan.
No, the private respondent.
Respondent.
So that is page number 18, my lordship's order.
He also made the construction without having any sanction plan.
That
This
is
not the subject
what
matter.
are you to say.
I find an petition against him also.
Very well. Take
The-
steps.
Yes.
But the content
My
matter,
lord, kindly,
the
my lord,
petition is that. That's why this matter was not being asked.
my lord, kindly see. Then my lordship's order, page number 24,
Yes.
on fourth line, my lord, to file an affidavit of undertaking for self demolition. Page number 20, that is the undertaking filed on affidavit. Page number 2020. But nothing, as you know, kindly direct the district magistrate to at my cost, let it more. We are since 2022, we are against these your lordship's order. They filed the contempt, the appeal, page number 37. Appeal also dismissed, challenging my lordship's validity and legality of my lordship's order. Page number 37, can you see that is also dismissed. At page number operative portion, page number 40. Accordingly, we do not find any infirmity in the order. Under appeal, no construction can be made without a sanction from the competent authority. The appeal being such and such is dismissed, fair and dismissed. Challenging my lordship's order. That's why, since 2022, we are
Which authority is this?
the authority, the subdivisional officer is the authority. According to Panchayat Act, subdivision.
What subdivisional officer? Is it a panchayat land?
Yes, another constitution Panchayat matter, my lord. That's why. That is response number 7, page number 5.
You did not make the panchayat pradhan a party?
Panchayat Gam, yes, my lord. That is 1. That is 4. Page number 5, top 4.
Page number 5.
Subdivisional officer is the competent authority. That is.
Where is the contempt? The contemner. Who is the contemner?
Contemner the private respondents against which my lordship's order was there to self.
Did you not make the government officials as party?
That is in the writ petition. Since your lordship can to self demolish and to file a affidavit undertaking, they filed. That's why they are under the contempt only.
Where is the undertaking?
Undertaking is page number 20, page number. Page number 20.
Page number 20. What is the affidavit?
That is there as by my lordship's order. I have shown to file undertaking that I shall.
Prakash Chandra Maiti.
Yes.
Are you representing Prakash?
Page number 24, my lordship's order was there.
No, I saw.
Give undertaking that you will self demolish.
You have undertook to dismantle the additional floor.
No, I have given this undertaking.
Yes.
No.
You have given the undertaking to demolish.
I have given the undertaking as per lordship's direction. Lordship directed to give an undertaking. That's why I have given the undertaking to dismantle. No, I have dismantled. The part of the unauthorized portion.
Why the rest is there?
The unauthorized portion. I have got the sanction plan, but which is the unauthorized portion, your lordship directed me to demolish the unauthorized portion.
Yes.
I demolished the unauthorized portion. Apart from the building which is within the periphery of the sanction plan, that building is revived.
No, my lord. This is absolutely incorrect. But my lordship's order was there. Whether in the sanction plan they have failed to produce.
Show me your sanction plan.
My sanction plan I have got, but at the present moment, I have not brought the sanction plan in the contempt petition.
Then fix a matter any day,
Wait, I see the
next
difference.
week, any day, can fix up the matter
We understand
as
that.
2 p.m. matter.
And is not about it 4 months time. An additional floor you constructed. Did you?
Paragraph 3 of my undertaking.
That is also misleading.
The undertaking has been given before this court.
No, sanction plan entire.
Paragraph 3. I further say that it is true that the petitioner had obtained a sanction plan.
Against that, my lord.
Unit building. Paragraph 3. Building from the concerned Gram Panchayat. And after
Which Gram Panchayat? You don't know the Gram Panchayat? None of you know?
Talgathari, one Gram Panchayat. That is page number 6.
Please come.
Talgachur, one Gram Panchayat.
The petitioner complains of violation of the undertaking given by the private respondent to self-demolish the unauthorized construction. Paragraph. According to the private respondents / contemners, the unauthorized portion has been demolished. Stop. Paragraph. Let a report be filed by the
Page number 4, the Pradhan. Bottom.
let a report be filed by the subdivision let a report by the subdivisional officer.
Yes, ma'am.
Kontai subdivision be obtained from the Talgachari 1 Gram Panchayat to ascertain the extent of unauthorized construction at what is the premises?
Premises plot number 2, 3 and 104 by 240.
Where do I get it?
Page 11.
Page 11. Acha. Unauthorized
Paragraph 6.
construction over jail numbers 204 and 205 on plot / dag numbers 2, 3 and 104 by 240, Khotian numbers 520, 741 and 1172.
Mal.
Stop. A spot inspection shall be conducted by the Gram Panchayat upon notice to the petitioner and the private respondents. Stop. The SDO shall file the report before this court on 5th February 2026. Let this order be communicated to the subdivisional officer for compliance. Take back this photograph.
5th February. March of last month. I sleep.
210, my lord, I appear on behalf of the petitioner, my lord. In compliance of your lordship last order, my lord, I have served the copy of the contempt application upon the contemner, but till date they have not complied with order.
Who is the contemner?
Contemner is the Pradhan Badla Gampa.
All right, give me the service.
Yes, man, kindly.
None appears on behalf of the contemner despite service. Affidavit of service filed in court is taken on record. Let contempt rule be issued, returnable on 5th February.
5th February. Yes.
211, my lord, Abhishek Prasad has appeared on behalf of the alleged contemnant, my lord. I am praying for not today, my lord. His mother was feeling not well. He has not come to the court, my lord. My lord, in the matter order was compliant, my lord. Recent order was passed, my lord. But I have no copy. My lord, is not there.
None appears on behalf of the petitioner slash applicant at the time of call. No accommodation sought. Application stands dismissed for default. Given your name. Only your name can be given. Nobody who's not present, appearance can be recorded. Followed? What is your name?
Ankita De.
Likhen into? Yes.
My lord, advocate and record Mr. Sholil Kumar Maite is ill, my lord, paying for not today.
Accommodation has been sought for on behalf of the learned advocate representing the petitioners. Stop. Released 5th of February. Next.
For the petitioner. The order dated 27th of February 2024, your lordship directed the.
Who is the contemner? Show me the service.
My lord, this is not sorry.
5th of February.
Not kind.
What? Not today. Next.
Item number 214, I am for the petitioner, my lord. Lordship, we are served the content application upon the Panchayat Pradhan, my lord, but the service is misplaced. Kindly, may I come back with proper affidavit of service, my lord?
Service is misplaced.
Yes, my lord.
Will you be able to get the track report and the postal receipt? Or you are required to serve afresh?
My lord, kindly adjourn. Kindly give me 1 week time, my lord.
All right, I'm making it not today. Next.
I am for the petitioner. Let's alleged contemner has appeared on the last occasion. Well, it has not been complied with your lordship's order.
None appears on behalf of the contemner. Stop. The order of the court has not been complied with till date. Stop. Let contempt rule be issued. Returnable on 5th of February 2026.
Great.
My lord, I am for the petitioner, my lord, led by Miss Sibjani Shengupta. My lord, I am praying for not to lordship. My lord, she is engaged in court room number 6, lordship. I am praying for only.
Has the order been complied?
No, lordship. The order has not been complied, lordship.
Then why are you seeking adjournment? Are you there?
I find, my lord, that whatever the order was passed, there's a communication to the petitioner. From the record, I find, my lord, that কবে কি দিয়ে ওর চিঠিটা কবেকার
তাদের নাম লিখে দাও খালি।
Could not identify the land?
No,
My lord.
that is what they have said so. And that was communicated. I don't remember any response
lord.
from
My lord.
Whereas it was communicated much earlier date.
My lord, they submitted erroneous report, lordship. My lord, your lordship directed the respondent authority to make spot inspection with prior notice and conduct hearing with the necessary parties and pass the reason order.
they conduct spot inspection lordship, and on that day they conduct a hearing and pass the reason or pass the report lordship. But erroneous report they submit that the petitioner could not identify the question of the premises lordship, but the petitioner duly identified, but the erroneous report has been submitted lordship. I made a representation lordship.
Are you aware where
Yes,
the
Lordship.
unauthorized construction has been made?
Yes, lordship.
You know it?
Yes, lordship. I made again representation for re-inspection lordship with the concerned authority lordship, the the executive engineer, building department, Borough 16, Kolkata Municipal.
Do you have a photograph of that unauthorized
lordship.
construction?
Lordship.
Please give. Is it annexed anywhere?
Lordship. Yes, lordship. Lordship, I have annexed in the petition lordship.
There is a photograph over here which says it's a side photograph. Is it something like this?
Yes, lordship.
Is it the same photograph?
Lordship, this.
Let me see. Which one is the construction? This structure?
Road lordship.
This structure?
Structure along with road lordship.
I can see one advocate's name over here with the phone number. Is it the advocate's property?
No, lordship.
You see it? I can see the name of the advocate and the phone number. The bottom pictures.
Lordship keeps it on the next day. We will bring fresh photographs, my lord.
Yes,
We will show
of
it
the
to my lord.
unauthorized
Of the
construction.
unauthorized construction. Kindly grant us
And
the leave.
I'll adjourn it for a fortnight.
My lord.
You take photographs and hand it over to your learned
Also,
senior friend.
premises number, because the university referred to a particular premises number
Yes,
they have
yes,
given.
yes,
My
yes. With the premises number,
My lord,
so
we
that
shall.
his officers can identify it.
Lordship, we shall do that.
I am keeping this on record.
Yes, yes. But the only but the other papers are there. If that communication, I don't know whether the other papers, what are the other papers, but
Check
only that, my lord, the letter, I can, my lord, hand over to your lordship court officer.
The communication made by the executive engineer within bracket C building department. Borough
আপনি জিজ্ঞেস করে নিতে পারবেন অফিস এখান থেকে
X IV
16, my lord.
তাহলে আমি করে দিচ্ছি
on X VI.
আচ্ছা ওই ওকে
X VI.
এই যেই খাতাটা শুধু এই পাতাটা আর বাদ বাকিটা আমাকে দিয়ে দিন।
ডেটটা দেখে নেবেন তো। Filed in court is taken on record. Stop. It appears therefrom that the authority was unable to identify the land where the unauthorized construction has been complained of. Stop. Learned advocate for the petitioner is directed to produce fresh photograph of the unauthorized construction, properly mentioning the premises number so that it can be easily identified. Stop. Let such copy. Now let the photograph be handed over to the learned advocate representing the contemner / corporation by 11th December, next Thursday. You want some more time?
2 weeks time, my lord.
All right. 18th of December.
18th, my lord.
Release the matter for further consideration on 22nd of January 2026. Stop. An updated report from the corporation shall be placed before this court on the adjourned date. যে চিঠির ডেটটা হচ্ছে 5th of February 2025. আর executive engineer
Well, I handed over the copy to be kept in the record. I've given it.
I'm deeply obliged, my lord.
Ordinance 17, my lord, I am for the petitioner, my lord, pursuant to your lordship direction on 12th September 2024. Directed the petitioner to serve the copy of the contemner. I serve.
No.
There is a affidavit.
Contemner.
my lord, the
Well, I
executive
accept that he has
engineer,
served it, but the
407.
copy has not come to us. Well, for
Executive
extras,
engineer,
well,
407.
if my lord, if it gives a copy, well, I can assist your lordship, because sometimes when it is served on the
ठीक है.
person concerned, it comes late, well, to the department, and that
1 year late.
no,
Well,
1 year,
kindly
I
kindly
don't say,
see-
well, I do what
well,
my lord is
kindly see the
observing.
file I served.
Yes, more than a year back.
But I feel shy to say anything because we are facing a lot of problems, well, to act on for this institution right now.
Kindly see
Not
your
earlier,
lordship
but
order.
this
Kindly
time we are finding the more difficulties.
page
Take
page
it up seriously.
Well, taking about
page 19. Kindly
to my capability, I have been as far as possible when I'm taking that steps.
You are the best person to take such steps. Nobody else will be able to deal it in the manner you do it.
the developer is
Give it,
raising
give it.
construction,
All
but
right, give a
police
copy.
did not take any steps. My lord,
Give a copy
pursuant
to
to
me.
your lordship direction.
Please come. Let a copy of the contempt application be served upon Mr. Alok Kumar Ghosh or your junior.
Yes,
ওনার জুনিয়রের নামটা লিখে দেবেন তো for taking instruction in the matter. Stop. Relist 5th of February 2026.
My lord, is it
Affidavit
1
of
year or
service.
your lordship pass an order, my lord?
What can be
Kindly,
done?
kindly month of
well, in view of a lordship's
month
order,
of
but
January,
whatever
my lord.
even
Month of January, my
taking
lord.
the
kindly.
order, a copy of the looking at your lordship's direction, or whatever things to be done right
Please
now,
do it.
I'll do it.
Month of January, my lord. I'm facing
January,
it.
no
Well,
time. I have fixed so many matters. Next.
For the petition, Lordship. Lordship, the order has been complied with.
All right. Complied with. Learned advocate for the petitioner submits upon instruction that the order of the court has been complied with. Step. In view of the above, there is no requirement of proceeding with the contempt application any further. Stop. The same stands disposed of.
Right, I am for the petitioner. Last occasion, there was direction to serve copy upon the alleged. I have served the copy.
Who is the contemptor?
Pradhan, Beunta Gram Panchayat.
None appears on behalf of the contemptor despite service. Affidavit of service filed in court is taken on record. Rule returnable 5th of February. আরেকটা দেখে নি একটুখানি yes
My lord, direction I have served copy the contempt.
who is the contemptor?
Balurghat municipality.
Balurghat municipality.
Board of Councillor of Balurghat municipality. 4% there.
None appears on behalf of the contemptors despite service. Affidavit of service taken on record. The rule is issued, but virtual presence. Virtually present থাকবে অন্যগুলোতে personally লেখা থাকে. This will be virtually 5th of February. 5th of February, rule will be issued, put in the requisites.
Yes.
It appears for the first time, madam.
Please serve. First day appearance, returnable on 5th of February 2026.
443, I'm from the petitioner, my lord. Order has been compliant, my lord.
443?
443.
All right. Order compliant.